Chairman, can you hear us?
Chairman, can you hear us?
Thanks.
Thanks.
I'm getting an echo in the room. Oh, well, we'll figure it out. Good morning. We are on the record in case number 2021-370, electronic investigation of the service rates and facilities of Kentucky Power Company. My name is Amy Covage. I am Vice Chairman of the Public Service Commission, and I will be presiding today. Joining me today remotely are Chairman Kent Chandler and Commissioner Mary Ann Butler. For those in the hearing room, please set your cellular phones to silent mode or turn them off. In light of recent increases in COVID cases, we continue to take precautions, including limiting the number of persons in the hearing room, social distancing, and cleaning the witness table between witnesses. I don't think we'll have any in-person witnesses today, but in the case we have a surprise witness, disinfecting wipes have been placed at the witness table. We ask each witness to wipe down the witness area with the wipes at the conclusion of your testimony. For those witnesses who will testify at and counsel who will participate by video conferencing to assist with audio clarity and avoid feedback issues for the video conference hearing, please mute your microphone and turn off your video if you're not speaking. If you're using a phone for audio and a computer for video, please turn off the computer audio, otherwise there will be feedback. If you are in a room with several people on their own computers, turn off the computer audio for all but one computer. I've learned that one the hard way myself. Otherwise, there will be horrendous feedback. If another participant is in a nearby office, please close the doors between the offices because sound carries further than you might think. Once in the GoToMeeting software platform, go to your settings to ensure the microphone is on the microphone you are using. There's a pull-down feature in the GoToMeeting settings that will list all of your available microphones. Please use wired headphones or wired earbuds for better sound quality, and wired is preferred so you don't have a wireless device that loses power during the hearing. Keep a charger nearby, and please, as always, alert the Commission if you are experiencing technology failure that prevents your participation at any time in the proceedings. An attorney should contact staff at the previously provided cell phone number. Again, the hearing today is for the purpose of taking evidence on the following topics related to the pending acquisition of Kentucky Power by Liberty Utilities. Although that's not precisely true. That's going to be a different docket, excuse me, for the topics related to the notice that we had issued. All changes related to the Mitchell operating agreement that Kentucky Power anticipates will be necessary as a result of the pending transaction between Liberty, Kentucky Power, and AEP Kentucky Transmission Company, also known as Kentucky Transco. The federal, state, and local regulatory approvals that must be obtained regarding the pending transaction between Liberty, Kentucky Power, and Kentucky Transco. Kentucky Power should be prepared to identify with specificity all local, state, and federal tariffs, permits, and agreements that will be affected by the pending transaction. A tentative timeline of the proposed transaction, including but not limited to the anticipated date the proposed transaction is expected to be filed with the Commission for approval. To the extent that Kentucky Power knows the impact of the pending transaction on the relationship between Kentucky Power and Kentucky Transco, any concerns and comments received by Kentucky Power from its customers regarding the pending transaction and how the customer concerns and comments have been addressed, the nature of the pending transaction, such as whether there will be an assumption of liabilities and if this is a stock purchase or asset purchase, what agreements are in place between Kentucky Power and Liberty, such as a memorandum of understanding, stock purchase agreement, or asset purchase agreement, any other related matters. I know other parties have also filed proposed topics for cross-examination, and I also acknowledge that Kentucky Power has filed some objections to the hearing topics, and we'll address those in a bit. At this time, could I have the entry of appearance of counsel? First, for Kentucky Power.
Thank you. Thank you, Madam Vice Chairman. I'm Mark Overstreet with the law firm of Stites and Harbison, 421 West Main Street, Frankfort, Kentucky. Appearing with me is Katie M. Glass, also with the law firm of Stites and Harbison, and we're here on behalf of Kentucky Power Company.
And I believe you also have one witness with you remotely, is that correct?
That's right. Mr. Madison is, his square appears on the Hollywood squares.
Okay. For the Attorney General.
Mike West for the Attorney General's office. John Horn is here as well behind me, and Larry Cook is on the GoToMeeting software.
Okay, for KIUC,
Morning, Your Honor. For KIUC, Mike Kurtz and Jody Kyler-Toner.
thanks. For Sierra Club,
Thank you, Madam Vice Chair. Good morning, everyone. Matthew Miller, on behalf of Sierra Club, along with Bethany Baxter of Childers and Baxter PLLC.
thanks.
I'm here as well. Yep, thank you.
And for Walmart,
Good morning, Vice Chairman Carrie Grunman and the law firm of Spillman, Thomas & Battle, here on behalf of Walmart Inc.
for commission staff,
Good morning, Vice Chairman Nancy Goodsell and Joe Penny.
thank you. And I have been advised that public notice has been given and filed into the record. Is that correct?
That's correct. We filed the proof of publication on November 24th.
Thank you. And I know there are some outstanding motions. Is that correct?
Yes, that is correct.
Sorry.
It's
Sorry,
not-
I caught you drinking, didn't
We have, Kentucky Power had a notice of objection and a supplemental notice of objection to the scope of hearing, or to hearing topics. And second, there was a motion to cancel this hearing that was filed that has not been ruled upon.
I? Okay. Obviously, since, I'll take those in reverse order. Since we're here, I know, obviously, we did not cancel the hearing. I know there was a response to the motion that asked for this to be turned into an informal conference, discussing more the other docket, I believe, related to the Mitchell documents. We obviously aren't turning this fully into an informal conference, but at the end of these proceedings, we will let you have some discussion about timing and some of the topics that we were going to discuss, that you asked to discuss in that, so that we can expedite and have a little smoother ride in the other docket related to the Mitchell documents that have been filed. So if that's okay with everybody, we can take that up at the end. Now, regarding the objections, I guess, Mr. Overstreet, would you like to address that motion before we commence with testimony?
Surely, Your Honor. We have filed our written objections, and we'll stand on that. But I'd like to sort of address a larger topic, if I might. And that is, it's a reasonable, informed, and just decision in any case, I think requires two things. And first, it's an orderly process that's known in advance, with all parties on an equal footing, and with the subject matter of the process reasonably cabined. And respectfully, that is not what has happened since September 15th, when this investigation was started. This has grown, like my grandfather used to say, like Topsy. We are now addressing topics that were identified for this proceeding as diverse as no-load fuel cost, which were the subject of the settlement agreement in case 2014-396, the Rockport deferral, which was the subject of the settlement agreement and commission order in case 2017-179, the Mitchell agreements, which are the subject matter of the recently filed 2021-00421, and then we've also have the yet-to-be-filed joint application by Liberty and the various AEP entities and Kentucky Power, which, an important participant to that application is not even, Liberty is not even a party to these proceedings. And this sort of sprawling proceeding doesn't lend itself to the sort of reasonable and fair procedures that are, I think, they're the hallmark of what this commission has stood for in the 41 years I've been practicing before it. There's no malicious intent, it's just what's happened, but I think the commission should take this opportunity to essentially rein the process back in and one that's more manageable for the commission, more manageable for staff, more manageable for the parties. In doing so, no one will lose the opportunity to fully address and fully litigate the issues that have been identified to date as being important to them. The Mitchell agreements can be fully litigated in 2021-421. Both the Attorney General and KIUC have been granted intervention in that case. There's been no procedural schedule, as you indicated, Madam Vice Chairman, and hence there's the time for intervention has not been established, and that cabining those Mitchell agreements to that case will allow for a full, fair proceeding that comports with due process, but I think equally important will allow the commission to make a reasonable decision as opposed to this sort of scattershot procedure that we enjoyed here. The question of Liberty's acquisition of Kentucky Power Company and Kentucky Transco is the subject matter of a yet-to-be-filed application. The stock purchase agreement requires that it be filed within 60 days of October 26th. That is rapidly approaching, and again, we fully expect the Attorney General and KIUC to, along with any other of these interveners, to seek intervention, and the Commission will rule on those. But those matters are best addressed in those proceedings where everybody knows what's at issue, where there's a procedural schedule, where there's an opportunity for written discovery to be taken, where there's an opportunity for testimony to be filed, where there's an opportunity for Kentucky Power to take discovery of the other parties. That's not what's happening here. And then, so that's, I think, the first hallmark of what the Commission has stood for in the last 41 years. The second hallmark is, and I say this respectfully, reasonable notice. And reasonable in terms of timing. We received the Commission's topics last Monday, and that would have been 1, 2, 3, essentially 3 or 4, however you count them, business days prior to this hearing. We received the AG's topics the next day. That's 2 or 3 business days prior to this hearing. And then we received KIUC's the following day, 1 or 2 business days. That, respectfully, is not time, particularly given the scope of the topics, is not sufficient time for the company to identify witnesses, prepare witnesses, and address the issues. Now, the company, finally, the company has attempted to be responsive. We have filed the written responses to the Commission's decisions, the Commission's topics. We filed written responses to Mr. West's topics, and we've tried to be as responsive as is reasonably. We would thus ask that our objections be sustained, and that this proceeding, this November 30 hearing, be limited to those topics identified in the Commission's October 28th order setting this hearing for today.
Does the Attorney General have any response to the motions? Or motion?
Yeah, just a brief one. We'll leave it to the commission to decide what is reasonable notice for putting a company on notice as to what they should be prepared to discuss at hearing. I would just note that I interpret the October 28th order to be a little bit broader, the one that had set this hearing to be a little bit broader than what the company had, in as much as it said that the commission will be taking evidence on the pending matters. And to me, that's broader than simply limiting this hearing to discussion of the potential proposed changes to the operating agreement regarding the Mitchell plant. So certainly, whatever the commission thinks is appropriate regarding notices, we'll go with, but just wanted to make that note.
Okay. Mr. Kurtz, do you have any response?
Yes, Your Honor. We view this as really a discovery, more of a discovery hearing than a hearing on the merits. There's not really any issue that the commission needs to decide as a result of this. And it's a discovery hearing with respect to issues that are huge. The proposed acquisition of Kentucky Power is one of the biggest decisions this commission is going to make because of the nature of what's at stake. And the commission is limited to 120 days to make that decision. So getting an early start is in the public interest. To the extent that Mr. Madison doesn't know answers to questions, well, then he doesn't know because of the short time frame. But everyone's on a short time frame, and the commission is acting responsibly by getting ahead of these questions. Mitchell is a good example of why it's important to get ahead. The company AEP filed at FERC on November 22 for approval of the Mitchell agreements. AEP did not wait for this commission to say, we agree with this, you should change that, and then file revised contracts at FERC, or they went ahead and assumed complete approval of the agreements at FERC as is. Comments, protests, answers by the commission and the other party are due December 13th, 2 weeks from now. And if no answers or protests are filed, these tariffs will be on file, go into effect as a matter of law on January 19th, 2022, before the commission is asked to rule on the Mitchell agreements. So what you'll have is, if there's getting an early start to know what to tell FERC, what type of protest or answer is important, because if the FERC contracts go into effect as rate schedules, that will be an allocation method, and under Kentucky law, the affiliate transaction, section 2207, I think, that will then be the way for the affiliate transactions to be valued. Without a FERC schedule, it's the higher of fair market value or net book cost, which is rate base. When Mitchell was transferred to Kentucky Power by Ohio Power about 10 years ago, it was at rate base, net book cost. Now the proposal is to not box in the commission, but to make it a fair market value, adjusted fair market value transaction, eliminating the higher of provision under Kentucky law. So it's important to address the Mitchell questions now, and I think history shows that given the interstate nature of the AEP companies, it's important to be careful. The Hanging Rock Jefferson transmission line from years ago, which you may have heard reference to, the Rockport contract itself was preemptively forced on the commission through a FERC case. Similar to what seems to be happening at Mitchell, the transmission agreements, the commission has expressed concern about those as recently as its last rate case order, and surprise as to how that's happening. The Mitchell no-load fuel costs certainly took the commission by surprise, a $54 million disallowance by surprise. And so approaching this with as much information as possible, that the Mitchell transfer and the proposed acquisition is prudent and reasonable and in the public interest. Thank you.
Mr. Miller, I know you didn't file any topics, but do you have anything you'd like to add with respect to the scope of the hearing?
Thank you, Madam Vice Chair. You're correct. And no, I will just say that Sierra Club understands and respects the positions of KPC and the other parties. We are relatively neutral as to how the commission wants to proceed, so long as issues are in fact, raised and aired and presented in other dockets related to the Mitchell operating agreement revisions and the acquisition by Liberty. We are content to litigate those in other dockets. And so, in a word, we're fairly neutral on this motion. Thank you.
Staff, do you have any argument with respect to the scope?
Our only position is that inevitably there's going to be a great deal of overlap, and that we should not foreclose the opportunity to discuss relevant matters relevant to this case, because there are other cases that are pending or have just been filed.
Chairman, or, well, I'll go to Commissioner Butler. Do you have anything? Oh, forgot you, Ms. Grundman. I am so sorry.
That's okay, Your Honor. The only thing that Walmart would say, we have recently been a participant in some proceedings in Virginia as it relates to some newly enacted legislation. And in somewhat similar fashion, trying to figure out precisely what would be determined on a given docket was somewhat confusing. And we would defer to the commission in terms of what gets heard today, but would certainly appreciate as much guidance as the commission can provide as possible regarding what will be heard in these various proceedings moving forward, so that we can make an educated decision about when to participate. As it relates to the commission's order scheduling this hearing, we felt like it was very clear. And in some ways, this proceeding has morphed in part because what appeared to originally be a discussion about Mitchell and what was going to happen has been confused somewhat by the sale to Liberty. And so, we would certainly defer to the commission as you all let us know what will be heard in proceedings, but would certainly appreciate any guidance you can provide in advance of these proceedings coming up, as you've done so far.
Commissioner Butler, do you have any questions for council you'd like to ask?
Not at this time, thank you.
Chairman Chandler, do you have any questions you'd like to ask?
I do have just a couple for Mr. Overstreet. I just want to make sure that I understand today. I will have to cut out a little early, but my two questions are: is Mr. Madison going to be able to indicate to the commission who at Kentucky Power directed counsel to file the changes in the Mitchell agreement in a separate docket instead of this one? I just want to make sure he's the correct witness to ask that question of.
Mr. Chairman, I don't know whether he's the correct witness to answer that question. He unfortunately is having technical problems, and GoToMeetings won't allow his video to connect. He can call in.
He has called in.
Oh, he has called in. I apologize.
Okay. Well, and we'll ask it of him anyways. And as Mr. Kurt said, if he doesn't know the answer, that's I don't know is certainly an acceptable response. The other is, do you know if he'll be able to respond on behalf of Kentucky Power as to who directed counsel to file the changes in the Mitchell operating agreement before the commission had approved the changes? File those changes at her. Excuse me.
Well, I think there's two parts to that. The first part is, I'm not I'm not sure whether he knows that response, but I would point Mr. Kurtz and the commission and the parties to the actual language of the FERC filing. which provides the parties have filed for approval of the Mitchell agreements with the West Virginia Public Service Commission and the Kentucky Public Service Commission. To the extent that either the West Virginia Public Service Commission or Kentucky Public Service Commission require changes to the Mitchell agreements, the parties may need to amend the agreements as filed herein, and in that case, will make the necessary filings with the commission, being FERC, and that's on page 7 of the FERC application.
Right, but, and I can appreciate that, but I just, and maybe I won't be here, so maybe it would be handy for Ms. Vinsel to sort of take note of this, but the commission's order, setting this hearing almost a month ago, specifically said that Kentucky Power shall request commission approval prior to any change to the Mitchell operating agreement. And so I'm just wanting to understand factually, from whichever witness, if it's Mr. Madison, that's great. If there's not a witness today that can speak to that, that's fine. We will file that in written form, so that we can understand what the process was, who at Kentucky Power directed the council to file those filings.
Your Honor, if I might, we certainly believe we were acting fully consistent with the commission's order. We brought this application to the commission for all necessary approvals. We also brought, Wheeling also filed with the West Virginia Commission, and as is, I think typical, there was a filing made at FERC, but that filing, particularly carves out the possibility that there may be changes made. The commission obviously has the ability to intervene and file objections before FERC. There's a need to start the environmental work at Mitchell and to enable the proper accounting and to comply with this commission's orders regarding the ELG part of the work. We needed to go ahead and start the process. But we brought those two agreements to this commission on November 19th for approval.
Well, and we'll talk about, I didn't necessarily want to get into that, but I think the commission's order initiating this docket, so again, I don't know how it can be argued that it's not sort of the company was on notice that this may be an issue in this case, this Mitchell operating agreement. The commission's order initiating this case, which is from September the 15th, I think, said that insofar as the commission doesn't provide a path forward by order in this matter, and this is in regard to the Mitchell operating agreement, Kentucky Power should use this docket to propose recommendations on any of the subjects mentioned or related to those discussed herein, should deviations from regulations be necessary to accommodate requests or applications made in this docket. The commission will give due consideration to any motion requesting such deviation. In your, the supplemental notice filed by you or Ms. Glass yesterday, referenced that and noted that after you noted that the commission asked Kentucky Power to use this docket to propose recommendations related to the Mitchell plant and other matters. And then you go on to say, however, as the issues raised by the commission and interveners themselves reveal, events have overtaken the investigation initiated by this docket. So I kind of feel like you're arguing that we're not staying within the bounds of this initial case, while simultaneously using any other thing that's been referenced in this case to then take things that are clearly on point with the initial order, the Mitchell operating agreement, to then say that discussions about those changes to the Mitchell operating agreement should be discussed in other dockets. And it feels like you're citing the extraneous things that are mentioned by Mr. Kurtz or the AG or what you feel like we've gone out of bounds with our initiating order in this as a reason not to discuss in this docket those things that you agree were wholly envisioned by the initial. And I don't know how that's necessarily consistent. I guess my question on this front, Mr. Overstreet, is with the Mitchell operating agreement, and the sale, you're now telling us that we shouldn't discuss those or ask questions about those today, even though they were squarely within the initiating order of this docket, because the company has filed a separate application to change the Mitchell operating agreement, and that the company intends on filing a transfer of control case along with Liberty in the future. But when this was, that transfer of control is a direct response or a direct outcome of the strategic review that was part of the basis for initiating this case, and that the majority of the responses, when we asked about the strategic review at the last hearing, we were told we don't have a definitive answer yet, and therefore we can't give you any responses. We'll let you know when something has been announced. Now the company's position is, we'll wait until we file the application. This is not the right place. How is all of that being consistent, and how was the company not on notice about that the commission in this docket was interested about changes to the Mitchell operating agreement and changes in the potential ownership of Kentucky Power?
Your Honor, KRS 278-020-7, 6 and 7, 7 and 8 require that the joint applicants file an application which by necessity would result in a separate proceeding. I don't see how we can comply with the General Assembly's directives without filing that separate docket, that separate application, which would by statutory necessity result in a separate docket. With respect to the Mitchell operating agreements, we filed it as a separate application for approval. We're not trying to escape commission review, commission approval, and even if FERC rules, it still requires, the FERC filing still requires, the changes still require all three commission approvals, FERC, West Virginia, Kentucky. So we feel like that we've been as responsive. We've provided the commission, the parties, with as much information as we possibly can. With respect to the transfer application, we're not the only, we, Kentucky Power, are not the only party involved in that. We have Liberty involved in that. I can't speak on behalf of Liberty, both as an ethical matter and I think as a practical matter. We think we're trying to comply with the commission's order. We've acted in good faith. We've provided the information. What we are requesting is that these matters proceed in an orderly fashion where we know what's at stake, what's at interest, in time to properly prepare, that we have the ability to take discovery. At some point, that sort of process, which is one that the commission has used for decades, will enable everybody to reach the proper decision.
Right. Respectfully, Mr. Overstreet, it seems like it's not that you don't want to talk about these issues, is that you have a preference, it seems like, to do it in a piecemeal fashion when the company is the one who drives the process through an application. And that's perfectly fine for things in which the company is seeking a particular outcome or bears the burden of proof. And that, I agree, will be the case for a transfer of control under 278-020. And I fully expect that the company will have to file that application under 278-020 for the transfer of control. But what we specifically discussed at a hearing over a month ago was that the commission had an interest in using this docket to ascertain as much information as possible, because as you're well aware, 278-020 has a statutory deadline of 60 days that can only be extended for another 60 upon a showing of good cause by the commission, right? And that you've also now in your Mitchell transfer request, your Mitchell operating agreement request, have requested a finite date in which you are seeking commission approval for that. And I think it's approximately 3 months. And so I can appreciate the idea of having some orderly process, particularly when the company bears the burden of proof. But this is an investigation in which we've already said we're attempting to do fact finding in a not necessarily an open-ended manner, but in a way in which we can get the answers to questions we need, because we will be handcuffed in our ability to fully vet these issues, if for no other reason than the time-limited manner in which those matters have to be processed. And so I appreciate that. That's not necessarily, that's my Bob Cicero statement, not necessarily a question. I appreciate you indulging me, and I'll make sure that I send along my questions to Ms. Vinsel, and hope you all will excuse my absence for a short period during today's hearing.
Mr. Overstreet, I'm sure it's not going to come as any shock that we are going to overrule the general objection, though obviously we will entertain specific objections to certain lines of questioning. I mean, I'll go ahead and say there are some topics on the KIUC outline that go pretty far afield, so please feel free to make your objections as we go to individual topics rather than us going through those right now. I think I will say generally to your concerns about an orderly process, that's understood, and the point of this is not today to fully litigate the Mitchell agreements, to go into depth about the transaction that's going to occur. Obviously, Liberty is not here, but the very fact that this is a daunting and sprawling process that we are about to engage in is why we're here today, and to get more, just some higher level information and clarity so we can plan for how we're going to process the Mitchell filing, hopefully within the deadline that's been requested, and how we're going to get through the transaction in that time period. So we do think that there has been ample notice. Obviously, to the extent Mr. Madison doesn't know something, he's free to say, I don't know. We're not going to get into the nitty-gritty of the Mitchell documents today. Those have been filed in a separate docket. There'll be plenty of time for discovery on that. But one question I would ask before we move on from the topic is the complications caused by the FERC filing. If FERC rules and approves the documents before this commission can rule, I take it by your argument that the company is not going to argue that there is now then preemption and this commission has no ability to ask for changes or to disapprove the documents.
It's my understanding that the application at FERC itself acknowledges the possibility that either this commission or the West Virginia Commission may ask for changes, and that Kentucky Power, has reserved the right to go to FERC and ask to amend that. It's also my understanding that the Mitchell agreements themselves encompassed or recognize the need for all three commissions, the FERC, the Kentucky Commission, and the West Virginia Commission, to approve the documents. With respect to the with respect to generation matters, there is joint jurisdiction between the states and FERC. It's different than transmission, which Mr. Kurtz referenced. So if you like, I'm happy to consult further with my clients and try to provide you with something more definitive, but that is my understanding.
Okay, and if we decide we do want something more definitive, we can follow that up in a post-hearing
Thank you.
request. I'm not going to pin you down today because I surprised you with that question. Well, we will go on, and I hope no one has decided to pop on late for public comment and listen to all that. But anyone who wishes to provide public comment may do so by following the instructions located on our website at psc.ky.gov. Let the record show that the instructions and link to provide public comments have been posted on the website for the past day. Have we received any requests for comment, Ms. Fensel?
We have not.
Okay. Please note that comments may always be submitted on the PSC's website at psc.ky.gov or by mailing them to our mailing address. And with that, I believe it's time for Mr. Madison, although we've been going 45 minutes. I don't know if you're willing to take a break during Mr. Madison or if you'd rather take a break before.
It's whatever suits the commission and the parties, but I just wanted to, excuse me, bring to the commission's attention the fact again that Mr. Madison is using the same equipment that he's used to appear in the past, but for some reason he cannot connect via video. He is on GoToMeetings, and it's my understanding he's also called in.
He's also caller one.
So, yes, and so he can hear us, and I assume we'll be able to hear him when he unmutes his phone, but I just wanted to make sure that everyone understood that his video is not functioning.
Okay, understood, and we'll note that for the record. Obviously, he can't help that, so we're not going to hold that against him. Does anyone else prefer to take a break before, or would you rather us just go ahead and charge through?
I hate to say this, but I'm having a bit of a technical issue. If I could have just a brief break.
Yeah, why don't we take a 10-minute break, and that way we can hopefully get through Mr. Madison before we take another break. With that, we'll be back, let's say, at 9:55.
Thank you.
Are you there, Commissioner Butler?
Yes.
Okay, then I will take that as a sign that you can hear us. Okay. We're back on the record. Mr. Overstreet, at this time, you may call your witness.
Madam Vice Chair, Kentucky Power calls Brett Madison, who is actually appearing by video.
Okay, Mr. Madison, could you please raise your right hand? Do you swear or affirm that the testimony you are about to give is true and correct and under penalty of perjury?
Mr. Madison,
You're still muted.
You need to unmute.
No, still muted. There we go.
What about now?
Yeah, give us your I do again and for the penalty of perjury.
I do.
Could you please state your name and address for the record?
Brett Madison, 1645 Winchester Avenue.
Okay, and can you also identify any records or related material you have with you?
I have my testimony and I have the Kentucky Company Supplemental of Notice of Objection hearing topics. Those are the two items that I have.
Okay. Counsel, you may ask your questions.
Thank you, Madam Vice Chairman. Mr. Madison, have you caused to be filed in this proceeding any testimony or verified data request responses?
Yes, I have.
In this proceeding? I'm sorry, in connection with this hearing, I apologize.
With this hearing, are we talking about my testimony and the
I'm sorry, I've confused you. That's my fault. I was speaking since the last hearing in this matter, which I think was October 5th. Have you caused to be filed in this proceeding any additional testimony or sworn to data request responses?
No, I have not.
Okay, thank you. That's all the questions I have.
Okay, but just for clarity, I know the responses to questions from the commission that were filed, those are not sworn to now by Mr. Madison, that's from counsel?
No, Mr. Madison was involved in the development of that, but we were unsure, because they weren't issued as data request responses, we didn't file them as verified. He's available to answer questions about those and will do so.
Okay. On behalf of the Attorney General, any questions?
Yes, I have a few. Hello, Mr. Madison.
Hello.
Before we start, some of my questions will probably overlap or relate to what was filed yesterday afternoon, and for the sake of making sure that I don't miss anything that I was looking for, and for the sake of the people who might be watching remotely, I would ask that we cover these questions. But so my first question relates to the employees of Kentucky Power. Can you just talk a little bit about their reaction to the news of the transaction with Liberty?
If you're referring to the most recent announcement on October the 26th, is that what you're referring to?
Yes.
Yeah, well, I'll take you back to about mid-April of 2021. AEP announced that there would be a strategic review of the potential sale of assets of Kentucky Power, Transco, and all assets of Kentucky Power, and that was made known publicly and to all the employees. At that time, there were several, as you can imagine, questions by employees, which at the time, a lot of them couldn't be answered from the perspective of how's that going to affect me, will I have a job, those type things. So on October the 26th, 2021, that's whenever it was made known to us and then publicly announced. Prior to the public announcement, we visited with all our employees to let them know that there was a successful bidder in the strategic review of Kentucky Power, and it was Algonquin Liberty Corporation. And at that time, there was a joint letter from Liberty to let individuals know that they would have a job. Reactions were, again, okay, we now know that Kentucky Power has a successful bidder. When are we going to know a little bit more? So recently, in the last 3 weeks, Liberty has come out, actually gone to every site location, visited with employees, and I was also attending those meetings, and employees were very much, I think, interested, and some to the point of they think that the future looks good for them because they were all reassured that every single employee would have a job and continue to have a job. So we've not had any negative reactions, any concern. They're looking forward to this process and moving forward with the Liberty Corporation.
Thank you. I think that fully addresses my questions about the employees, but just to move on, in the agreement that was announced between Liberty and Kentucky Power, did Liberty and Kentucky Power make any agreements addressing the future operation of Mitchell?
No, none that I'm aware of.
Did the parties come to any agreements related to the allocation of costs as it relates to the future operation of Mitchell?
No.
Now I'm
And
going to ask,
if I could, excuse me, I'd just like to make note that the change in the Mitchell operating agreement is necessitated as the order by this commission and the West Virginia Commission were different. If you recall, I believe it was the way we phrased it. Case 1 was CCR and ELG. Case 2 was CCR only, and that's what this commission approved, was CCR only, while the West Virginia Commission, with Wheeling, our 50% undivided partner in Mitchell, approved both CCR and ELG. So it naturally evolved into we had to change the Mitchell operating agreement. So this is done irregardless of whether there's a transaction with the strategic.
thank you for that clarification. So let's talk a little bit about the proposed changes to the Mitchell operating agreement that were filed in the new docket 2021-421. Does Kentucky Power anticipate that any further amendments will be made to the operating agreement beyond those indicated in that docket if the Liberty transaction is finalized?
No, what we filed is what we anticipate are the changes needed to the Mitchell operating agreement, irrelevant of the transaction.
Was Liberty involved in the amendment of the operating agreement or discussion of the terms of the amended operating agreement?
The operating committee, which is made up of a representative for Kentucky Power and Wheeling, were involved in the changes. Liberty received a courtesy copy. They had no objections, but they were not involved in the details of the changes in the operating agreement.
Okay. You mentioned the operating committee. Can you discuss what the operating committee, how the operating committee operates and is constituted now, and how it will be if the proposed agreement is approved?
Well, the way it operates now is it's a committee that is made up of one representative of Kentucky Power, which is myself, and then of Wheeling, which is president of APCO, and then a gentleman named Tim Kearns that runs and manages the day-to-day operations. He is an officer of Indiana, Michigan Power Company, an AEP company. And it works as outlined in the agreement, where the day-to-day operations and the operator currently of the Mitchell plant is Kentucky Power, and we have a 50% undivided interest in the plant with Wheeling. And as I mentioned earlier, the decisions made by the two commissions naturally evolved into and necessitated a change in the Mitchell operating agreement to basically make Wheeling the operator, and we would remain a 50% undivided interest owner in Mitchell plant until we are out of the Mitchell plant on December the 31st, 2028. But it works the same that it's always worked since there's been an operating committee established.
Just so I understand, how many members are on the committee?
There's voting members, one from Kentucky, one from Wheeling, and then Tim Kearns serves on the committee. He does not have a voting interest, but he is the day-to-day operations individual of the Mitchell plant.
So with two voting members, the potential exists for a split decision on various issues, correct?
Well, mathematically, it could, but the interest of the operating committee is to ensure that the Mitchell plant, remains in operation and is prudently operated to maintain a consistent flow of power. But that's never happened to where there's a split.
Would it be more likely that opinions could differ amongst members of the operating committee when the two companies are no longer owned by the same parent?
Your Honor, I'm going to object. I think that calls for speculation on Mr. Madison's part.
Mr. Madison, I mean, do you have any response to that question?
Well, my response would be that I can't speculate what may happen in the future.
That we can move on.
Okay. Can you give us a high-level overview of how the new proposed operating agreement differs from the one that's currently in place?
Sure, and in my view, and I just see it as being a simple business transaction necessitated again by the difference of the two commission rulings, that again, just naturally, Kentucky Power will no longer be involved in the Mitchell plant as of 12/31/2028. So you're basically taking the current existing Mitchell operating agreement where it shows that Kentucky Power is the operator and also is a 50% undivided interest in the plant, and moving Kentucky Power out of the operator and making Wheeling the operator. They'll be responsible for day-to-day operations. Kentucky Power will retain and maintain its 50% undivided ownership in the Mitchell plant through midnight of 12/31/2028. At that time, Wheeling will take over 100% and move forward as the operator of the Mitchell plant, owner and operator. There's also one thing that will happen because this commission, the Kentucky PSC, did not approve ELG. We will ensure that there are no costs borne by Kentucky ratepayer by any ELG costs that are incurred. And as noted in my testimony, one of the ways we want to ensure that is we will hire a technical expert to ensure that all costs are prudent and that only CCR costs will be borne by Kentucky Power ratepayers. So that's kind of some high-level overview of changes in the new agreement.
Just real quickly, when you're referring to your testimony, are you referring to the testimony that was pre-filed in 2021-4/21?
Yes.
And Mr. Overstreet has indicated yes, so.
I don't want to speak for the witness, but that was my understanding of what he
Okay,
was referring to.
just wanted to make sure that everything was clear, that we weren't talking about the answers to questions here, but that other filed testimony. Is that right, Mr.
No,
Madison?
yes, 4/21, that's correct.
Sorry for the interruption.
No, it's fine. You touched on a couple areas that I want to get into a little bit more detail on. First, the technical expert that's called for to allocate costs between Kentucky Power and Wheeling, related to the ELG costs. How will that technical expert be selected?
Well, it'll be selected by the operating committee.
How will the company guard against conflicts of interest on the part of that expert?
Could you expand that question, conflicts of interest, in what regard?
Will the technical expert be internal to any of the companies involved in the operating committee?
No, it will be a third-party external technical expert that has experience in these type matters on the ELG. Will not be an internal individual.
Does the current operating agreement have a transfer process outlined in it, or is that a new addition in the proposed operating agreement?
It's a new addition with the two methodologies of a transfer. I believe it spells out in the testimony I referred to earlier that there's two methodologies. The price agreed upon between the two parties, being Kentucky Power and Wheeling. And of course, that would have to be approved by the commission. And if that takes place, then that process would need to begin, as noted, in 2026. So there's plenty of time to move in that direction of an agreed upon price approved again by the commission. Or, there could be what's the fair market price at the time. Those are the two proposals we have in the new operating agreement.
Okay. With regard to the fair market value valuation process that's outlined in the agreement, am I correct that consideration is given to decommissioning costs under that method?
That is correct.
Is it your understanding that those decommissioning costs would be prorated based on the amount of energy the parties received from the unit over the years or not?
I'm not exactly sure on exactly the details of that.
So you're not sure if it would be prorated, those decommissioning costs would be prorated in any way?
Well, I don't believe that I would be the proper witness to answer the details of exactly how that methodology would work.
Okay. Who would be the appropriate witness to answer something like that?
I would think somebody like, when we start talking in the dollars, how to allocate cost and those type things, somebody like maybe an Alex Bond would be a good witness.
Okay. Just 1 minute. I want to see if I missed anything here. I guess just one more question. The application requests that a decision be made on or before February 17th on the operating agreement proposal. Is that correct?
Yes.
Can you talk about the necessity for that and why that date was selected?
Well, the issue of CCR and ELG compliance is time sensitive as governed by environmental rule. And so we're trying to get this process done as expeditiously as possible without getting involved in any delays to make sure we meet the environmental requirements. And this was the promptest way we could get this done without robbing Kentucky Commission of any of its powers, because this is a time-sensitive issue.
Just one more question. The proposed operating agreement allows for the possibility that a transfer could occur, but it doesn't necessitate or require that a transfer will occur. Is that correct?
I would agree with that.
In the event that Kentucky Power retains its ownership interests in Mitchell and a transfer does not occur, how would costs be allocated to Kentucky Power customers after 2028?
But we would not be involved we could not be involved in the Mitchell plant after December the 31st, 2028, because this commission has not granted approval for ELG. Therefore, I'll go back to the technical expert that we've hired to ensure that no Kentucky customer or ratepayer pays for any of the ELG costs. As I mentioned earlier, that this is a natural progression by way of ruling from each of the various jurisdictions, being Kentucky Public Service Commission, West Virginia Public Service Commission, that we will not be involved in the Mitchell plant past 12/31/2028.
When you say would not be involved, does that mean the ratepayers will not bear the costs for?
Bear the cost for what?
Continuing involvement with Mitchell plant.
When you say for the Mitchell plant, from what time period are we talking about? After 12/31/2028?
Yes.
They would not bear any cost for the Mitchell plant after 12/31/2028.
Thank you.
You're welcome.
Mr. Kurtz?
Thank you, Your Honor. As to the Mitchell operating agreement, or really the ownership agreement, I have just one set of questions on the buyout transaction and the buyout price. And I do have the list of issues we submitted last week. Mr. Madison, I know we're not into the Mitchell case, but you did sponsor the two new Mitchell agreements in the Mitchell case, correct?
Yes, that is correct.
So I take it you're familiar with the agreements?
Fairly familiar, yes.
Okay. Do you have the agreements in front of you?
No, I do not have them in front of me. I've got them online. They're 100, and, combined, both of them were very lengthy, so I didn't print those out.
Okay. Well, could you go to the proposed ownership agreement? I just do have just one set of questions on the buyout price. And that is the ownership agreement, section 9.6, page 15. Just let me know when you're there.
Could you tell me what page that is on?
15.
15. Okay, the page 15 that I've got starts with, it says capital cost to be incurred. Is that the page you're on, top left?
No, it's the ownership agreement, section 9.6.
Okay, it starts out with this underlined 9.6 buyout transaction.
Yeah, buyout transaction, and then A is buyout price.
I'm there.
Okay. As a member of the operating committee, first of all, were you involved in the negotiation of this agreement?
I was involved in the development of this. Yes.
Okay. Section 9.6A, buyout price, is defined as the adjusted fair market value of the Kentucky Power interest minus decommissioning costs plus the coal inventory adjustment. Is that correct?
That's what it says, yes.
Now, in the definitions, which would be page 24 of the agreement, adjusted fair market value is defined. I don't expect you to have it memorized. Can you turn to page 24?
I'm there.
Okay. And recall that the buyout price is adjusted fair market value minus depreciation, minus decommissioning plus the coal inventory adjustment. So we start with adjusted fair market value, means any positive amount, if any, but it could be zero, equal to the fair market value minus the CapEx adjustment. Is that your understanding?
That's what it says, yes.
Okay. Fair market value is the process with the three, well, it's a defined term on page 27. Let's go to that.
All right, I'm on 27.
Yeah. Okay, so fair market value, which may be a positive or a negative number, is equal to 50% of the cash price obtainable with an arm's length transaction, and that's where you will have the three independent experts determine the fair market value of the power plant. Correct?
Yes.
Okay. So the adjusted fair market value is fair market value minus the CapEx adjustment. I want to ask you about the CapEx adjustment, which is a defined term on page 25. Are you there?
I am.
Okay. So this is a reduction to the fair market value, and the CapEx adjustment is 50% of any capital expenditures or portion thereof, including ELG capital expenditures, to the extent funded by Wheeling in an amount in excess of 50% of the total amount thereof on or prior to December 31, 2028, plus weighted average capital carrying costs. Is that your understanding?
That is what it says.
Okay, so you'll have the independent experts determine the fair market value, and then you will subtract from it the amount of the ELG expenditure that Wheeling made, which is in excess of 50% of the total. So in other words, the 50% of ELG that Kentucky Power did not pay will be reduced from the fair market value. Is that correct?
That's the way that states, yes.
Okay. Also, to the extent there are other CapEx costs that the Kentucky Power does not pay, that will also be reduced from the fair market value, correct?
That is correct.
Okay. Plus a carrying charge.
Right.
So let's go back to the buyout price. Adjusted fair market value, again, which is fair market value minus the CapEx adjustment, which is the ELG capital costs that Kentucky Power has not paid, and any other capital costs. So the adjusted fair market value could be a negative number, isn't that correct?
It's possible.
For example, if the fair market value was 0 and Kentucky Power's capital cost of the ELG, which in the ELG docket was estimated to be $49 million, the adjusted buyout price would be 0 minus 49 plus interest on the 49 million. So it would be a negative number in that example, correct?
Mathematically, that'd be correct.
So this is a form of clawback that Kentucky Power consumers would pay for the ELG because it's a reduction, it's a reduction to the fair market value price they will receive. Isn't that right?
No, I don't necessarily agree with that. I think the intent there is when you look at ELG specifically and the way that it's laid out, there is a value to ELG, and Wheeling is bearing all of that cost. So if, let's say that the plant was worth $1 and they spent $10 on ELG and it increased the asset value by that $10, then that asset's worth $11. So you would have to deduct, to be fair to Wheeling, since they bore the cost, the ELG cost, because Kentucky was not and should not be involved in any ELG, nor should they get credit if there is any credit given to the asset appreciation because of ELG costs.
If the fair market value was 0 and the ELG CapEx adjustment was $49 million, Kentucky Power starting with a negative balance, a negative starting point of $49 million off the bat in this equation, correct?
Mathematically, that would be correct.
Okay. If Kentucky Power just walked away from the power plant, all they would owe is decommissioning, right? But for this transfer agreement, there would be no responsibility for Kentucky Power ratepayers to reimburse Wheeling for the $49 million of ELG costs that Kentucky Power did not pay. Isn't that correct? But for this agreement.
Well, I think it goes back to the illustration I gave. The ELG cost enhanced depreciated the value of the plant. You can't give Kentucky and Kentucky ratepayers credit for that. That's what that equation is set up to do. And I can't speculate sitting here today, 7 years plus, a little bit over 7 years from now, what the value of the plant will be. Who knows what will be happening in the energy market at that time.
Okay, so let's go back to page 15, the definition of buyout price. Adjusted fair market value, which is the 3 experts evaluation, minus the CapEx adjustment, which we were just talking about, minus decommissioning costs. And that's a defined term as well, correct?
Decommissioning cost?
Yes.
Yes.
In the definition of decommissioning, I did not see a netting for negative salvage. In other words, when you decommission a power plant, you sell the steel, and an electric arc furnace company buys it and melts it. I did not see any netting of revenues associated with decommissioning in the definition. Did I miss that?
I don't believe there's a mention of netting in this statement.
Well, shouldn't Kentucky Power get credit for any net negative salvage, any value that the plant might have when it's being decommissioned?
Your Honor, I've tried to be patient with the level of detail, but I think Mr. Kurtz has gone beyond what Mr. Madison can reasonably be expected. All of these issues can be addressed in full detail in the Mitchell agreement agreements case, it's my understanding, I'm not here to testify, that the net value or the transfer value cannot be less than zero, but again, that can be fleshed out in the Mitchell agreements case.
Yeah, and it's understood that the company will have a full opportunity to address all of these issues. This won't be the only shot. And to the extent that Mr. Madison can answer this question, that's great. It's understood if he can't at this point, since there is the other docket. So, I'll overrule the objection, but with the instruction that, we aren't here today to litigate the whole Mitchell document, so.
And I really do just want to understand, because we have to file comments at FERC,
Right.
protests within 2 weeks. And I just want to make sure I understand what we're going to protest about.
Yeah, no, Mr. Madison, if you need him to repeat the question, we can do that, or if you remember it, you can go ahead and answer.
Thank you. I don't need him to repeat it, but at this time, I don't think that I would be the person that could answer that granularity of a question.
What about the value of the land after it's remediated to a industrial quality site? Do Kentucky Power consumers get any credit for that in the decommissioning definition?
Same objection.
Is it mentioned somewhere that we are going to get it to an industrial quality site?
Yes, it does. That's in the definition of, decommissioning, or it's in there somewhere, but yeah, it's going to be remediated to an industrial grade site.
Yeah, and
Well-
it overruled to the same extent that hopefully we're getting, this is as deep as we're gonna get into the specificity.
Is there any credit given to Kentucky ratepayers for the value of the site after the power plant is torn down and it's an industrial site along the Ohio River with transmission connecting it?
I don't want to speculate at this time.
Okay. The last element of the, so it's adjusted fair market value minus decommissioning plus the coal inventory adjustment. That one is fairly straightforward. That's just the value of the coal left on the ground after 12/31/28, correct?
Yes.
What about other consumables like lime or limestone for the scrubber? Does Kentucky Power get credit for that?
I don't want to speculate as to what that might be.
I don't think it's in the agreement. Let me ask you, let's go back to page 15, section 9.6B. I want the determination of fair market value with the three experts and the appraisers and so forth. I want to ask you one question about this, which I'm sure was negotiated. The appraiser for the fair market value is going to look at the future estimated revenues associated with the plant, capacity, energy, ancillaries in the PJM market, less cost to get a net present value fair market valuation for the plant. Is that generally how it will work?
If I said that's specifically how it'll work, it'll be an assumption, but generally I would agree with that.
And so there has to be an assumption as to how long the plant will be operating to do the fair market value analysis, correct?
Your Honor, I'm going to raise the same objection. All of this can be just addressed in the 421 case.
Yeah, noted and overruled.
So there has to be a life of the power plant assumption in the fair market value analysis. Would you agree?
I would assume so, but you're getting in an area that I'm not an expert in, so I'm not going to speculate.
Well, this is addressed in the agreement, and it's the middle of paragraph B on page 16, 12 lines down, assuming that the units would permanently cease operations as of December 31, 2040, or such earlier anticipated date as may be filed by Wheeling with the West Virginia Commission. Do you see that?
Yes, I do.
So if Wheeling filed with the West Virginia Commission that it anticipates ceasing operations at Mitchell in 2035, for example, that would change the fair market value determination compared to an assumption that it would operate through 2040, correct?
It could,
Your
possibly.
Honor, excuse me, Mr. Madison. Your Honor, I believe Mr. Madison's indicated in response to an earlier, or at least the predicate to this this question, that he was not the person to address this issue. And then, again, we're not only getting deep into the weeds, but we're talking about things that would be addressed in both the Mitchell agreement case and any case involving the transfer of Kentucky Power's 50% interest to Wheeling, where these provisions would take place, take effect.
Again, he negotiated this agreement with his counterpart on the operating committee, and we have to file comments in 2 weeks, so.
But, Your Honor, this is an issue that, and I respectfully posit this. I don't think it's a proper use of an investigation by this commission to take discovery into matters that are pending before another regulatory body, or that frankly would be pending before this body in other dockets. I mean, that's fundamentally unfair.
Mr. Kurtz, any response?
Well, I think the answer is that he negotiated this agreement with his counterpart on the operating committee. We do have the FERC deadlines, and if he knows, he knows. If he doesn't know, he doesn't know. I don't think the result of this cross-examination or this hearing is going to result in a specific commission order. So I think the due process concerns are overstated. Like I said earlier, this is akin to a discovery hearing more than a hearing with a specific issue in front of the commission.
But Your Honor, that's fundamentally my problem. 278, 260 doesn't anticipate, and to my knowledge has never been used for such a wide-ranging discovery mechanism involving other cases. That's fundamentally not what 278, 260 is about.
I think you could concede, though, couldn't you, Mr. Overstreet, that we're in a fairly unprecedented situation here, both just with the type of transaction and the different transactions we've got going on, the conflicts between the commissions that led us down the Mitchell agreement amendments, overlaid with now a stock purchase agreement and a pending FERC filing, that we're in a fairly, we're in unplowed ground, so to speak.
I respectfully disagree. I've certainly been involved in multiple transfer proceedings, and to my knowledge, they've never been preceded by a free-for-all discovery proceeding. Everything took place in the General Assembly's 120-day period. The Mitchell two conflicting orders, I would concede are, to my knowledge, I've never seen that before. But I think this commission I'm fully confident that this commission has the ability to deal with that without taking discovery for matters that are going to be filed before the Federal Energy Regulatory Commission.
I'm going to allow just a little bit more. I mean, he has testified that he negotiated this agreement. We are here to talk about pretty directly the Mitchell situation, which is what necessitated, or what caused this hearing to be scheduled in the first place back on September 15th. I think it's fairly within the scope of the orders, but granted, we are getting pretty deep into it. I'm going to give a little more leeway, but please feel free to keep making your objections, and you're probably going to get one soon, so.
Thanks.
The question around the ability of Wheeling to change the fair market value analysis by simply filing with the West Virginia Commission and anticipated retirement date before 2040. Why did you not make that, instead of anticipated, a legally binding earlier retirement date?
Are you asking me why we use the word anticipated?
Yes, because that is,
Oh, look,
they could anticipate, but not carry through with it.
Your Honor, I have the same objections.
well, the answer is anticipated because we have no idea. We couldn't put a definitive date in that section.
Okay. I did want to ask you one other question Mr. West brought up. Your counterpart on the operating committee, what is his position?
He is the president of APCO Power under AEP.
Okay. What is his
And
business?
Wheeling reports to him.
At one point, I thought the president of Kentucky Power reported to the president of Appalachian. Is that no longer the case?
That hasn't been the case for a number of years.
Okay. So you do not report to your counterpart on the operating committee?
Not at all.
Okay. In your negotiation of this agreement, why did you not make it consistent with Kentucky law and make the transfer price the higher of the net book value, but not less than fair market?
Same objection, Your Honor.
Overall.
I don't believe I'm the person to answer that question. You're asking me a legal question, and I'm not a lawyer.
Well, just to be clear, I was asking is the negotiator on behalf of Kentucky Power.
I believe you asked me why I didn't follow Kentucky law.
Well, the transfer is shall, it be at this adjusted fair market value. And my question was, why did you not, in your negotiation, make it the higher of net book or fair market value?
Your Honor, I have a different objection this time. And 278.22071B encompasses the notion of a deviation from that statutory standard, so it's not necessarily inconsistent with Kentucky law.
No, I agree. If the FERC approves this would be the FERC allocation method, which would then supersede the higher of standard, which is certainly a concern that we have about the whole FERC process.
And I think we had talked about that we were going to address some of these FERC issues and whether there would be preemption because of this filing in a post-hearing request, or that we can also then work in the issue of the Kentucky law preemption recognition on this. I do think Mr. Madison has indicated he's probably not the best person to talk to about this, even though he was on the negotiating team. So I think we can handle it that way and move on.
Thank you, Ron. Oh, and one last thing. On the definition of mutual interest purchase agreement on page 27, Kentucky Power is required to post a $15 million bond or surety or something for unknown contingencies expiring on December 31, 2050. So that's another cost of the buyout.
Well, I think it's a prudent cost to ensure that there are no unknown issues. This will protect against that, is the reason for that.
Your Honor, those are my questions on the Mitchell. Now I want to turn to the questions that we sent in last week, if I could. Let me just ask this basic question about the proposed sale of Kentucky Power to Algonquin/Liberty. In your understanding, Mr. Madison, how will Kentucky Power consumers benefit from that proposed transaction?
Your Honor, that is definitely something that's going to be addressed fully in the transfer case. Mr. Kurtz will have adequate opportunity to ask that question. That case also is going to involve, once again, Liberty, which is not before this, and I believe Liberty should have, due process would suggest that Liberty should have a chance to
I'll withdraw the question. Transmission, Mr. Madison, what steps has Kentucky Power taken to address the transmission concerns that the Commission raised in the January 2021 rate case order?
Now, as I've mentioned in previous testimony, we listened and heard the commission loud and clear, and ever since that hearing happened, we have not put our projects in transmission in Kentucky Power Transco. We've done them through Kentucky, and we actually went back and had a filing before the commission and changed that allocation to where it would be strictly in Kentucky. So we heard the commission, and we followed these ever since.
That would lower rates slightly because of the different capital structure and returns on the Transco versus Kentucky Power, but that would not fundamentally get to the rising transmission costs under the AEP transmission agreement. Would you not agree?
Well, I'm not going to agree with that because I'm not really, I don't really know where you're going with that. I was trying to answer the original question.
I mean, I think the Transco has a 55% imputed equity capital structure and a return certainly higher than the 9.1 or the 9.3 the Commission awarded in the last rate case with 43% equity. So that element of savings would be there, but not the fundamental cost increases, correct?
Right, but I think back to your question, you had asked what Kentucky Power did as a result of the rate case ruling on January the 13th of 2021. We fundamentally changed how we process and go about transmission projects to follow exactly what the commission asked us to do. That would be my answer.
Okay. Have you taken any steps to see if Kentucky can be carved out of the AEP transmission zone and be a standalone transmission?
Not to my knowledge at this time.
Question 2, is it correct that when the Rockport contract expires on December 7th, 2022, there will be approximately $56 million in fixed cost savings?
That's my understanding.
Okay. Is that going to be something that is addressed in the Liberty transfer case, how those fixed cost savings will be used to the extent that you know?
Your Honor, I object. That matter was in fact addressed in 2017, the 2017 rate case, which involved a settlement agreement that Mr. Kurtz's client agreed to. And that the manner in which those savings are addressed are spelled out in that agreement. My client has deferred substantial costs, transmit dollars out of its cash register, if you will, as part of that agreement, and we fully expect Mr. Kurtz's client to live up to its side of that agreement?
Well, Your Honor, a deferral with a carrying charge is a pay me now, pay me later, so they're fully compensated for that. In terms of the use of the fixed cost savings, it certainly, I understand what Mr. Overstreet is talking about. The agreement was for the first piece of the fixed cost savings be used to assure Kentucky Power achieved its authorized ROE for 2023. It certainly did not address Liberty or the sale of Kentucky Power, so I guess we'll cross that bridge when we come to it. I can move on if you please.
Yes, this is one of the topics I think is perhaps not fairly implied in either of our initiating orders. So this is one, I think Mr. Madison has answered the best he can, and I think we should just move on from it.
Okay, thanks. I'll skip my number 3. Mr. Madison, the $52.4 million rate increase that the Commission awarded on January 13th, 2021, or 9.8%, is being offset through tax savings currently. Is that correct?
Did you say that was 9.8% return?
A 9.8% overall, or I guess base rate increase, maybe it's not, no, it probably is overall increase, the $52.4 million. The $52.4 million rate increase from January 13th, 2021 is being offset with the excess ADIT, unprotected, correct?
That is correct. We asked for 1 year to be offset with the 15-year remaining balance, and the Commission chose to accelerate that and exhaust the entire 15-year balance into 3 years in the January ruling. So that increase is being offset by 3 years of ADIT.
Okay, thank you. Is the unprotected excess ADIT expected to last until the end of 2023?
It's my understanding that it is.
Okay, thank you. At that time, consumers will see the 52 million. Never mind. I'll withdraw that question. I'll skip number 5. Number 6, let's skip. Speaking about the question 7 that I sent last week, the CapEx that would have been avoided at Mitchell had there not been an ELG investment, so that there would be a wind down of the unit in anticipation of a 2028 closing. Are those, but for those avoided capital costs, going to be, is Kentucky Power going to be protected against those through this independent expert review process you have set up with the ELG to make sure consumers pay no ELG costs? Will there be a protection against those other category of capital costs?
So I've been very clear on the ELG costs. No consumer of Kentucky Power will pay anything on ELG. And I think what your question is, I'll try to answer what I think it is. Are you asking about capital costs that would be normal course for Mitchell plant to continue operating? Is that what you're asking?
Yes, past 2028 that would be avoided had we had a 2028 closure.
Okay. From my understanding, the way that process will work is, let's just for simplicity's sake, say that there is an expenditure, a capital cost that occurs in 2026, and it's $10 of the full amount of that capital cost, and there's 2 years remaining for Kentucky Power to participate in the Mitchell plant. We would pay our 50% undivided interest in the Mitchell plant on that capital cost for 2 years, which would be 2/10 of the cost. The 1/10 we would actually pay because of our 50% ownership. And at 2028, we would bear no more cost of that capital cost that would continue operating the plant beyond 2028. It would be prorated.
I see that, but under the Becker wind down analysis, none of those costs would have been incurred, and Kentucky Power would have avoided 100%, not just the prorated.
Is that a question or?
Isn't that true?
Well, if the plant was to shut down in 2028 and would no longer be operational, that would be true for both Wheeling and Kentucky Power.
Right, that's true. Okay, so prorated, all right. Question 28, it's a long lead up. Do you, with Wheeling taking over as the operator of Mitchell, Wheeling is a small utility, is it not? Haven't looked.
Yes, they're small.
About half Kentucky Power size in terms of megawatt hour sales.
That's correct.
With Wheeling being the new operator of Mitchell, do you anticipate any no-load fuel costs or minimum load cost issues?
I don't, but I can't speculate on that.
Issue 9 was the buyout transaction, so I'll skip that. Issue 10, I think Mr. Overstreet addressed. Thank you. And issue 11, Vice Chair, we've touched upon that, and the Vice Chair has commented on that as well. So, Your Honor, I have no more questions.
Thank you. We've been going a little over an hour. Is this a good time, unless Mr. Overstreet or Mr. Madison object, to take another short break and then try to finish the cross, Mr. Madison, before lunch?
That's acceptable to this old man.
Would you prefer that, Mr. Madison, or would you rather push through?
If Mark needs to take a break, that's fine, but I can go as long as you would like.
Okay, well, why don't we take let's take a 10-minute break and come back at 11:10. We're adjourned. We're in recess for the break. You got a completely different person here than Chairman. Okay, I think we are back on, well, now we are unmuted. Are we, I think we're back on. Commissioner Butler, can you give me a thumbs up? Excellent. Mr. Miller, are you ready to proceed?
Yes, thank you, Your Honor.
And
Although
just
Sierra
give me a
Club has
second. Let's
no
let
questions for Mr.
Let's let
Madison.
Mr.
Thank
Madison
you.
get back on. Okay. Do you have any questions, Mr. Miller?
Thank you, Your Honor. No questions from Sierra Club. Thank you, Mr. Madison.
Okay, Ms. Grundman, do you have any questions?
I do, Your Honor. Thank you so much. Good morning, Mr. Madison. How are you?
I'm good, thank you.
I want to just sort of try to clarify a couple of timing issues that I'm struggling to understand. If I go back in this docket, although the 10-day updates are filed under docket number 2021-4, they are filed in this docket as well, the 2021-370, and it looks like you have been the signator on that update for every 10-day status report that's been filed with the commission. Do you recall helping to draft
Yes.
and file those?
Yes, I review those, yes.
And you understand that the point of those 10-day status reports is to notify this commission as to Kentucky Power and Wheeling Power's plans with respect to Mitchell and the Mitchell operating agreement?
Yes,
And so do you recall that the most recent 10-day status report you filed was on November 24th, 2021?
that is correct.
And prior to that, the one before that was on November 15th?
I believe, subject to check, I believe you're right.
And do you happen to have a copy of that update anywhere in front of you?
Let me see if I can find one real quick.
Ms. Grumman, are we discussing the November 24 or the November 15?
The November 15th.
Thank you.
I'm sorry, I don't readily have that available.
That's okay. I'm going to read it to you in case you didn't.
Okay?
On November 15th, the update you filed says, on November 5th, 2021, Kentucky Power filed its notice of intent to file an application for approval of affiliate agreements related to the Mitchell Generating Station. The commission assigned this proceeding case number 2021-00421. The company will file its application before November 30th, 2021. A comparable filing will be made at the same time in West Virginia. I have not read the entire update, but does that sound familiar to you?
Yes, it does.
And in fact, that filing was made on, that status update was filed on Monday, November 15th, 2021. And then that Friday, November 19th, you in fact filed your testimony and application with the Kentucky Commission. Is that correct?
Yes, that is correct.
And a comparable filing was made with the West Virginia Public Service Commission.
On the new Mitchell operating agreement, yes.
And a filing was made at FERC as well. Isn't that correct?
That is correct.
Can you explain to me why you failed to mention the impending filing with FERC when you filed the 10-day status report on November 15th?
Let me ask you this, was that included in the November 24th filing?
It
For
was.
for that very reason, because we would have put it in the next 10 day that happened after that filing we made on the 15th?
Well, help me understand, Mr. Madison. You provided the commission advance notice of your intent to file an application with the Kentucky and West Virginia commissions regarding the Mitchell operating agreement, correct?
Yes,
That's what the November 15th status update did, correct?
yes.
Why did you not similarly give the commission advance notice of your intent to file with FERC as well?
Are you talking about why we didn't do it on the 15th or because we did do it on the 24th?
Well, that was 5 days after you made the filing. I'm trying to understand why you did not also provide advance notice to the Kentucky Commission that in addition to making a filing with the Kentucky Commission and the West Virginia Commission, that you also intended to make a filing with FERC at the same time.
Well, I think if you go back and look at the 10-day status updates, there's some that have been pre and some have been post-filing status. At
Mr.
the
Madison,
time,
well, I don't want to get distracted. Are you telling me that on November
Excuse me, Your
15th,
Honor.
you were
Can
unaware
Mr.
that you would
Madison
be
finish
making
his
filing with
response?
FERC?
Yeah, let's, I think he's finished now, but let's try to be careful to not cut Mr. Madison off.
Thank you, Your Honor. Mr. Madison, were you unaware when you filed the status report on November 15th that the company intended to make a filing at FERC?
well, we did not know exactly when we were going to make the filing. It's always been apparent that we would be making a filing with both state commissions. Wheeling would make theirs with West Virginia, we would make ours with Kentucky, and then they would be made at FERC. We knew that had to be done. We just did not know at the time when we would be doing that.
When did you decide that you would be doing that?
Well, actually, we decided that the Thursday before the Friday that we made the filing, trying to consider the Thanksgiving holiday the next week. So that's why it was in the 10-day status update on November the 24th.
Mr. Madison, I think maybe you and I are somewhat talking past each other. I guess I'm confused. You make no mention on November 15th, 2021, in your status update to this commission that you were planning to make a filing with the FERC. Correct?
That is correct on the 15th.
Why did you not provide advance notice?
I believe he's answered the question, Your Honor.
Your Honor, the record will reflect that he has not provided an answer to that question, other than to say that they subsequently provided notice after it was filed. What I want to understand is why the company, why Kentucky Power did not notify this commission in advance that it was intending to make a statutory filing, as it provided notice that it intended to make state regulatory filings in Kentucky and West Virginia.
Yeah, overruled. Mr. Madison, do you have a direct answer for that?
My direct answer is that it's inherent that it has to be filed at FERC, and at the time, we had not filed it yet and did not know exactly when we were going to file with the two state commissions. So once we had that done, then we put it in our next 10-day status update. It's that simple.
Well, Mr. Madison, you knew, because you said so in your November 15th status update, you knew that you would be making filings with West Virginia and Kentucky by no later than November 30th, 2021, did you not?
We did.
Did you also know that you would be making a FERC filing by no later than November 30th, 2021?
I'm going to give you the same answer. It's inherent that it has to be filed at FERC. We did not know when we were going to file it. Once it was filed, and after the fact, on the 24th update, the 10-day status update, we included it in it. It's that simple.
Was there some sort of requirement that you make a simultaneous FERC and state regulatory filing?
I would refer to my attorney on that. I'm not sure of a legal requirement. However, it has to be filed in all three.
But you do not know, as you sit here today, whether those are required to be simultaneously filed?
Not off the top of my head, no, I don't.
Okay. And you believe that an attorney would be the appropriate person to answer that question?
If you're asking me a legal question, I definitely believe that.
Well, I don't know that I phrased it as a legal question, but okay. The next question that I have, and I guess I'm somewhat confused about, you've been asked some questions about the Mitchell operating agreement and what happens with it down the road. Do you recall some of those questions?
I recall a lot of questions I've been asked about it.
If things go to plan and consistent with the asset purchase agreement, Kentucky Power, as it presently operates today, as a subsidiary of American Electric Power, you would no longer be the operator and owner of Kentucky Power. Isn't that correct?
Your Honor, I'd ask Ms. Grunman to clarify her question. I don't know who the "you" refers to. Kentucky Power is a wholly owned subsidiary of AEP. I don't know whether she's referring, who the "you" refers to in that question.
Your Honor, if Mr. Madison has any question about it, I'm happy to rephrase it for him, but he didn't express that he didn't understand my question.
Your
Well,
Honor,
I actually didn't understand the question, so.
I'm happy to rephrase it.
Yeah, thanks.
If Kentucky Power's assets are sold to Liberty Utilities, Kentucky Power, as it presently operates today, will no longer be the same entity or legal, it will be owned by a different legal entity. Isn't that true?
objection,
That is
Your Honor.
absolutely true.
She's misstated the nature of the transaction. It is a stock purchase transaction. It is not an asset purchase, asset sale transaction.
Asked and answered. Regardless, I'm trying to understand why an entity that is seeking to engage in a sale is negotiating a contract that governs transactions 7 years down the road. So what I'm trying to understand is, why did Kentucky Power engage in negotiations with Wheeling Power regarding revisions to the Mitchell operating agreement?
Is that a question?
It is.
Okay, well, here's the answer, and I've said it repeatedly throughout this hearing and other hearings. The Mitchell operating agreement and the changes as filed has absolutely nothing to do with a transaction, a strategic study, or the impending sale of Kentucky Power. They have strictly to do with the decisions made by this commission, the Kentucky Public Service Commission, and the West Virginia Public Service Commission. This commission agreed with CCR only. The West Virginia Commission agreed with CCR and ELG. At that point, as we filed, we stated if that was the ruling of this commission, we no longer would be participating in the Mitchell plant effective December 31, 2028. So irregardless of an impending sale strategic review, this is totally independent of that. That's why we filed this Mitchell operating agreement with the changes as noted. They're not tied together in any way, shape, or form.
Well, you're talking about a change that would occur, as you just noted, on December 31st, 2028, correct?
That's whenever we would be out of the plant, yes.
So 7 years and 1 month basically from today. Correct?
Is that a question?
It is. It's over 7 years from today, is it not?
It's 7 years, 1 month from today. That's exactly right.
And so if all things go to plan, as I understand it, you and Liberty Mutual are going to make, Liberty Mutual, I apologize, Liberty Utilities or Algonquin will make a filing on or around the end of December with at most 120-day deadline to approve the sale of Kentucky Power to Liberty. Is that correct?
There would be a transaction filing that Liberty would take the lead on. They are the purchasing and acquiring company.
As the purchasing and acquiring company taking the lead, why should they also not take the lead on renegotiating the Mitchell operating agreement?
Well, I'll repeat my answer. It's independent of a sale. This sale right now
Your Honor,
is,
excuse me, Mr. Madison, she's asking
Yes.
why Liberty would or would not do something. I don't believe Mr. Madison is the witness to address Liberty's understanding or its plans.
Well, I'm sorry, Mr. Overstreet, but apparently you didn't hear the question. I asked why Kentucky Power or why Liberty Utilities shouldn't be the party to negotiate the agreement that Kentucky Power has negotiated. It has nothing to do with what Liberty will or will not do. It has to do with why Kentucky Power has taken the step it has taken, which is certainly within Mr. Madison's purview.
And he's answered the question repeatedly.
He has answered the question as to his belief that they are separate. And so my question is simply, why are you negotiating an agreement when you don't intend to be the owner or operator of the Mitchell power plant, when you intend to have, when the company intends to have no further agreement or ongoing affiliation with it in 150 days?
That's, excuse me, Your Honor, that's not true. The Kentucky Power will continue to exist after the transaction. Liberty is acquiring the corporate entity Kentucky Power. It's not an asset purchase. Kentucky Power as an entity will continue to exist. We're required to operate the business as an ongoing matter. we cannot simply put everything on hold pending the outcome of the transfer. And this is particularly the case in connection with the ELG, the necessary ELG work, because there are federal regulatory requirements about when that work gets done and when we have to, and then practical requirements of when we have to start it. That's why this filing that's why the work needs to happen, and that's why the agreements were proposed to be modified. Mr. Madison's testimony in the agreements case is very clear that this is not driven by the purchase, it's driven by the very fundamental operational needs of Kentucky Power and Wheeling Power as a result of the two conflicting commission decisions.
Let me see if I can break through this impasse, because I think we've got a couple of different things that are going on here. I know Mr. Madison has testified about that, and that's, I think, understood by the commission. I think Ms. Grunman's question is more to the fact that we have this stock acquisition, and I do think we've had some confusion because of the use and whether, and this is, Kentucky Power is the utility that is regulated by the Kentucky PSC, and it's going to continue to exist at least under the stock purchase agreement that I have seen. I think the fundamental question is, and I don't know that it's been very explored, and it may be that Mr. Madison can or can't answer this, is Liberty's involvement in the redraft of the Mitchell agreements, and has there been involvement or not? Is that fair, Ms. Grunman?
Your Honor, I actually think it goes further than that. The reality is even if Kentucky Power goes on as Kentucky Power, they will no longer be affiliates. So if the Mitchell operating agreement is renegotiated with Wheeling Power, when Kentucky Power is owned by Liberty Utilities, it's a very different negotiating situation than it is when two AEP subsidiaries or American Electric Power subsidiaries are negotiating an operating agreement. And quite frankly, I'm somewhat confused as to why the agreement is being negotiated today, because quite frankly, I don't understand. Mr. Overstreet just alleged that work would have to be put on hold if this weren't done. And I'm not clear that I understand what work would have to be put on hold. You're only talking about a 90 to 120 day delay in having Liberty Utilities be the party negotiating that agreement. So quite frankly, Your Honor, I think it has to do with the timing of everything, the interlap, the stock purchase, the confusion, the failure to disclose the filing at FERC with the November 15th update. To me, it all is just interrelated, and I don't understand the rush and why Kentucky Power, as it is currently owned and operated, is the one engaging in this negotiation of the agreements.
Let me do this, because there, obviously there was a lot of argument there, and the commission understands the timing concerns and all of that. Mr. Madison, can you explain further why Kentucky Power believes that the Wheeling, that the agreement for the Mitchell plant had to be modified prior to commencing the ELG work?
Sure. And at the risk of repeating multiple times, the Mitchell operating agreement stands apart and separate from the strategic review. We've said that consistently all along through these proceedings. I've said that in my direct testimony, that they are independent. They have nothing to do with each other. And when the rulings were in conflict with each other, both jurisdictions, Kentucky and West Virginia, there was no need, and it is a natural consequence as the result of those rulings, that Kentucky no longer needed to be the operator of the Mitchell plant. Wheeling needed to be the operator. Wheeling's bearing the ELG costs, not Kentucky. And that's why we made the fundamental basic changes in the operating agreement, where basically just simply took Kentucky Power, and now Wheeling will be the operator. We were the operator. We'll no longer be the operator. And by a result of this commission's ruling on December the 31st, 2028, we'll no longer be involved in the Mitchell plant.
That's understood, but that's not the question I posed. And maybe I didn't put it out there correctly. Could work have begun on ELG at Mitchell prior to getting approval for these agreements, with the understanding that Kentucky ratepayers wouldn't bear that cost?
It's possible, but I think it is a much cleaner way to operate when we know that Kentucky is not going to be the operator and we have no vested interest in the ELG costs to move us from being the operator to move Wheeling to be the operator, the one that's actually going to be performing and paying for the ELG work.
And I
Do
think
you
Ms.
know
Green-
the
oh,
timing?
You go on, Ms.
Sorry, Your
Green. I
Honor.
was gonna say, I was gonna turn it back
Do
to
you know
you.
Do you know the timing for when ELG work is intended to break, when they're breaking ground? That may be the wrong phrase on ELG work.
Well, I may not be the right, I don't believe I'm the right person to give the specific dates, but from my understanding, some ELG work and expense has already begun.
So you are able to do work on ELG upgrades, even though the Mitchell operating agreement hasn't changed the operator from Kentucky Power to Wheeling Power?
No, that's not what I said. I'm not talking about construction and those type things. There may have been some engineering work that has been done that would be required from a timing perspective, but I'm not the proper witness to answer that.
Who is that witness?
I would, I've lost the name for just a minute, but Mr. First mentioned him earlier. It's our environmental individual. I think it was it Gary Spitznagel? I'm not sure.
And so my recollection is that if we went back and look at Mr. Spitznagel's testimony from the last time we were here, or testimony, maybe that's an overly specific term, but when he was before the commission last, I thought he had provided some timelines and some sort of 18 to 24 month timelines involved with some of this work. Does that sound familiar to you?
He may have, but I don't have those with me or memorized.
And I think you said a minute ago that in your mind, and you've said it repeatedly, that in your mind, the sale, the transaction with Liberty is completely and entirely separate from this Mitchell agreement issue. Is that fair? I'm sure I have butchered your exact phrase, but you keep trying to separate the revision of the Mitchell operating agreement from the transaction, the sale to Liberty Utilities.
Well, I'm not trying to separate them. They are separate because this strategic review was just that. It was a strategic review, and I'm tasked with continuing to run Kentucky Power irregardless of a strategic review, if there's a sale or not a sale. And that will happen until this commission approves that impending sale to the successful bidder, which is Liberty.
But as part of that sale, it is true that Liberty Utilities would essentially undertake the obligations under the revised Mitchell operating agreements.
As they would with any other contract we have with any entity, any customer, any contract.
Do you consider the revision to the Mitchell operating agreement to be a material contract for purposes of the transaction with Liberty?
Material in what way? Define material.
Highly important, highly relevant to the terms of the deal between, with Liberty.
I wasn't involved in the negotiations with Liberty, and so the terms of the deal as you couched it, I have no idea. But to me, it's as important as contracts we have with anyone.
Well, certainly, it's not as important as a contract for the guy who mows the front yard of a building, is it? I mean, this is a substantially larger contract with substantially more dollars at stake. I mean, you understand, do you not, Mr. Madison, that materiality is a legal term of art used in the business community?
I do, but
Okay.
I do understand that. Did you have a question? I heard
So
that.
applying that terminology, materiality, would you consider the Mitchell operating agreement to be material as it relates to the transaction with Liberty?
My answer is the same. I wasn't involved in any of the negotiations with Liberty. So trying to get me to say this is material in regard to Liberty, I can't do that. I'm not that person.
Well, I'm asking for your opinion.
I object.
Mr. Madison, using your lay understanding of material, would you consider it material?
I would consider it a significant contract, yes. But it's not the only significant contract we have.
Who at Liberty Utilities was involved in any way with respect to revising the Mitchell operating agreements?
I'm not sure who that was, as I indicated, I believe it was Mr. Kurtz. I can't remember for sure if it was Mr. Kurtz, but we wrote and drafted the new Mitchell operating agreement. They were given a courtesy copy and had no objection, but I'm not sure who that individual or individuals at Liberty might have been that reviewed it.
So you're familiar with the document that was filed by your counsel yesterday?
Yes, I am.
And in response to item number 10, as it relates to the question of whether and to what extent Liberty Utilities Company had input on the changes to the Mitchell operating agreement referenced in case number 2021-00421 docket, the answer says, as described on page 13 of the direct testimony of D. Brett Madison filed in case number 2021-00421, Liberty has, and I want to quote here, agreed to and accepted the terms of the new Mitchell agreements as part of the pending transaction. If I understood you a moment ago, what you just said is that they were sent to them and you didn't receive an objection. So do you want to change the written answer that you gave to number 10, where you say that they agreed to and accepted the terms?
In my view, what I said is exactly what it says in my testimony. They were given a copy of it. They had no objection, which that's inherent to me that they agreed with it.
Are they a signatory party to that contract?
No,
Are they a named third-party beneficiary to that contract?
no.
So how do you know that they agreed to and accepted the terms of it?
I was told they were
By whom?
by our counsel that was working on the negotiation of the new Mitchell operating agreement.
What council was that?
You want their names?
I do, please.
One sitting in the room, Mr. Overstreet, was working as a third party. John Crespo and Kristen Blinn.
Okay. So those three individuals told you that Liberty agreed to and accepted the terms of the new Mitchell operating agreement.
Your Honor, I'm going to object to any further inquiry to communications between Mr. Madison and counsel. His answer is here on the page from Ms. Grumman too. I believe it addresses her initial concern about about why Liberty wasn't involved in the Mitchell agreement. It's clear that they agreed to and accepted the terms. If Mr. Madison was imprecise, he's now said that his answer to the AG's question was, in his understanding, the same that's on page 3 and 4 of the filing yesterday. I think it's time to move on.
Ms. Grumman, do you have any questions on that topic that would not invade attorney-client privilege?
Well, Your Honor, first of all, I'm not clear that I've invaded attorney-client privilege, but
I
the
don't
second
think you
issue that
have
I've
yet.
got is that I'm unclear, because what I thought he testified to, what I thought he said a minute ago, was that it was his understanding that it was sent to Liberty and nobody objected. What's filed here and represented to be in his filed testimony is they accepted and agreed to it. And those are two entirely different things. Receiving and not objecting and accepting and agreeing to are two different things.
And Mr. Madison has stated in response to Ms. Grumman's question that he understood them to be the same. If he has not spoken with the precision that Ms. Grumman prefers, he can address that, but he's said that in his mind, what's on the page and what he testified to are the same.
And just so I understand what page we're talking about, are we talking about what was filed yesterday? by
What was
Kentucky
filed
Power?
yesterday, there were the 4 pages of responses to questions. This is the response to question from the AG question. It's numbered number 10. It starts at the bottom of page 3. Whether and to what extent Liberty Utilities Company, Liberty, had input on the changes to the Mitchell Agreement referenced in the 2021-00421 docket. His answer, as described in page 13 of his testimony, Liberty has agreed to and accepted the terms of the new Mitchell agreements as part of the pending transaction. I think we've exhausted the topic.
Okay, well, and so that then takes us to page, which has then brought in page 13 of that testimony.
And
I just want to make sure I understand what we're fighting about here. And, shoot, I lost the page. And I have that testimony here.
It would be footnote 11 at the bottom of page 13.
So we're talking about the discussion of what does agreed and accepted to mean, correct, Ms. Grundman?
Well, I guess I was confused when he volunteered that it was sent to them, because I was trying to understand the involvement that Liberty Utilities had, because I was trying to figure out, obviously Liberty Utilities is not a living, breathing entity, so some human being within it with authority to act on behalf of Liberty Utilities had to have been the one to, as the company represents, accept and agree to the terms of it. So I wanted to understand who that was. And I think in the course of my questions, Mr. Madison indicated that his understanding of agree to and accepted is that they received the agreement and said nothing in response to it. So I don't mean to misstate your testimony in any way, Mr. Madison, but what I am trying to understand is who at Liberty you spoke to, who spoke to them, and how you drew the conclusion that anybody at Liberty agreed to and accepted the terms of the new Mitchell operating agreement.
Well, I believe earlier you said we were talking past each other. What I said was specifically is that they did not object. I've been involved in negotiations of multiple things. If I said to somebody and they didn't object, they accepted it. And that's what they did. And it's footnoted there, and they didn't object. Those are my words. It may not be illegal. They didn't object means they accepted it. They weren't involved, as I've stated multiple times, in the negotiations of coming up with the new Mitchell agreement.
And
they didn't have a seat at the table.
Okay, and so that, in some ways, your statement there, what rights would they have, if any, to object to the terms of the agreement?
As I said earlier, I'm not involved, nor have I been involved in the structure of the agreement that they've been working with AEP on the purchase of Kentucky Power.
So, Mr.
So
Madison, is
I
your
don't know.
answer, I
They didn't
don't
have a
know?
seat at the table, correct?
Not whenever we were negotiating the new Mitchell operating agreement, no.
And they are not a party to it either. I think we've already talked about that. When did you begin renegotiating the Mitchell operating agreement?
We began discussing the need that we needed to do something with the current existing operating agreement shortly, and I don't know the specific date, shortly after the ruling from the two commissions were in opposition.
When did you first exchange language with Wheeling Power concerning revised terms for the agreement?
I don't know those specific dates.
Approximate dates. I don't need a specific date, approximate dates.
Approximately within the last 60 days or so.
And so to understand the timing of just what proceedings we can expect to see before the commission, am I correct that you have asked for a ruling on the operating agreements filed in 2021, 421? Is it by February or thereabouts, February 2022?
I believe the date for February the 17th, 2022 is what we asked for.
And you intend to make a filing in December, I believe, in or around Christmas, with Liberty Utilities regarding the sale, is that correct?
No, that's not correct. It would be Liberty will be taking the lead as what date needs to be determined for them to file. They're the lead on this. They're the acquiring company, not Kentucky Power. So this would be fully something that Liberty would be in charge of.
Well, I think we talked about this at a prior hearing. I believe Ms. Blend helped to clarify it for the record for us, but I do believe that the stock purchase agreement dictates that it'll be 60 days from what I think was October 26, 2021. Correct? Do you recall that discussion?
I do, but that's, a statutory requirement, and I don't want to give speculation on the specifics, but I think 60 days sounds correct.
So that filing would get made in late December at the latest, and you would expect a ruling to be issued no later than 120 days after that.
Whatever the statutory requirement is for transactions such as this, I believe 120 days is the correct date.
So that's approximately end of April.
Yes.
Okay. And as part of the transaction with Liberty Utilities, they would undertake all contractual obligations owed by Kentucky Power, including the Mitchell operating agreement, either as presently constituted or if it is approved for revision.
You said owed, and that confused me.
Well, any contractual obligations that Kentucky Power has that are owed to another party as a result of a contract, Liberty Utilities would assume those obligations.
I would agree with that assessment.
Due to the impending sale and potential for approval from the Kentucky Commission, is there any reason that you would object to delaying a ruling on the revised Mitchell operating agreement until after a decision is made on the acquisition?
I can't give that answer today, but that's definitely not what our intent would be.
Okay. All right, I don't have any further questions. Thank you, Mr. Madison.
Ms. Fensel?
Yes, thank you. Checking the time. Good morning, Mr. Masson.
Good morning.
Follow up, I'm going to start with a couple easy ones for you, and then we'll move beyond that. In the response that was filed yesterday, you referenced the stock purchase agreement between Liberty, AEP, and AEP Transmission Company. In that response, you said that you had provided the commission a copy on, I think you said October 28th, 2021. Were you referring to an email sent to staff at the commission, or were you referring to a filing in a case at the commission?
I'm not 100% sure. I believe it was an email that was sent, I believe, subject to check.
Okay. Then I'm going to ask as a post-hearing data request that Kentucky Power provide a copy of the stock purchase agreement between Liberty, AEP, and AEP Transmission Company that was dated as of October 26, 2021, so that it will be in this record.
Sure.
And I'm also going to ask that Kentucky Power provide a copy of the common interest agreement between Liberty and Kentucky Power into the record of this case.
Your Honor, that has to do with relations among counsel. I believe I've actually not seen the agreement, and I would respectfully request the opportunity to raise any sort of issues with respect to that.
Yeah, when you get the written request, you can preserve all objections that you raise.
Mr. Mayor, I don't know if you heard the chairman. I don't see that the chairman is back on yet. Can you tell us who at Kentucky Power directed Kentucky Power's counsel to file an amended Mitchell operating agreements at FERC?
At FERC only, well, it was an agreement by the operating committee that at the conclusion of finalizing the new Mitchell agreement, that from a timing perspective, knowing that we have environmental specific dates that have to be met with the requirements, that timing is of the essence, and it's a natural consequence. If you file with the state, you need to file at FERC as well. So that was how we came to that agreement.
So you're saying it was the Mitchell Operating Committee who directed Kentucky Power's counsel to make this filing at FERC?
We concluded that that is what we needed to do, yes. We're going to have to make a filing at West Virginia, Kentucky, and with FERC.
So then someone else carried out the request to council after the decision was made by the Mitchell Operating Committee?
Yes, we informed them being, Mr. Overstreet, that we needed to make the filing with the Kentucky Commission and then whomever Wheeling utilizes, and then AEPSC would be the one that on our behalf made the filing at FERC.
And can you tell me when the Mitchell Operating Committee made that decision?
It was not probably, but around, I can't remember those dates. I think we filed on the 19th, so we made that decision that time frame, like the day before, as I said earlier, that we needed to make these filings.
So I want to be clear. I don't want to put words in your mouth. Are you telling me that Kentucky Power, the Mitchell Operating Committee made a decision and then Kentucky Power carried out a FERC filing in one day?
No, that's not what I'm saying. Whenever, as I mentioned to Ms. Grumman earlier, we've been 60 days or so, maybe 60 days plus, working on the new Mitchell operating agreement. Once it was in its final form, it was inherent that it had to be filed in 3 places, both states and at FERC. So it wasn't like we finished it on a Wednesday, filed it on Thursday, strictly for FERC. It's the same operating agreement that you have before you today.
Let me try again. I don't know if you didn't understand my question. Working on a Mitchell operating agreement is different from knowing that you need to make a change, which is different from a decision to finalize a document, which is different from a decision to file at FERC. So I want to make sure we're not conflating all 4 pieces. If the Mitchell Operating Committee determined that the agreements were at a point and there needed to be a filing at FERC, when was that decision made? Was it made on November 18th?
The decision to make those filings was made at the beginning of the start of the renegotiation of the contract, knowing that we needed to file at both state commissions and at FERC upon completion of the revised operating agreement. So that decision was, I hate to use the word obvious, but it was known early on that when we're through with this and completed the agreement, it has to be filed at both the 2 states and at FERC.
And Mr. Madison, I would agree with you and actually stipulate that you're right. It is obvious that Kentucky Power and Wheeling Power are going to have to go to their respective regulatory agencies, which are FERC for Kentucky Power here, for Wheeling Power West Virginia. I don't want to beat a dead horse. I think we're coming close to it. What I want to be clear is, given that on November 15th in that update, there was apparently uncertainty when a FERC filing would be made, and that a FERC filing was decided on November 18th and made on November 19th, that timeline just doesn't quite make sense, so I want to make sure that I'm understanding what happened when, without putting words in your mouth.
Sure. Let me try this. We knew all along from the very beginning, once the decision was made by the two state jurisdictions, one CCR being the Kentucky, and one being both CCR and ELG, that we would need to change the operating agreement, and we would be filing those changes with both states and at FERC. So we didn't wait until the day before to go, oh, we need to file this at FERC. We knew we had to file at the 3 locations that I stated upon completion of the agreement. We made the decision to file on that Friday because of, with the states and at FERC, you've got the Thanksgiving holidays coming up, and we were wanting to get it in prior to filing it last week. So that's why we chose to file it on Friday, the 19th. However, we knew from the very start, when we first started making pieces of changes that were needed to the agreement, that we were going to be filing at all 3 places. I hope that clears that up.
And did the Mitchell Operating Committee know that they would be filing all 3 filings at the same time?
That was our intent, yes.
Given that the FERC filing has a mid-January 2022 due date for a decision, can you explain what your thought, or Kentucky Power's thought was in filing at this request at FERC for approval of the agreements prior to the commission, this commission approving the agreements?
We didn't have any thoughts of anticipating differences of dates, that being an issue. We just knew that we were filing them all where we were required to file them at the same time.
So any question about federal preemption was not being considered? And I'm not asking you as a lawyer, I'm asking you as president of Kentucky Power.
Yeah, to my knowledge, without giving a legal opinion, I don't recall, from my perspective, that was something that was an issue. But again, I'm not an attorney.
To follow up with a similar question, can you tell me who at Kentucky Power directed council to file the request for approval of the changes in the Mitchell plant agreements in a different docket than this one at the PSC?
Well, I believe that what we did is we wanted it to stand on its own merit and not get confused with a potential impending transaction filing or the investigative filing docket that's open. We wanted the Mitchell agreement to be its own filing, so it would be much clearer and not be convoluted with other issues.
Okay, that you've answered my next question, so I'll go back to the first one. Can you tell me who at Kentucky Power made that decision to file the Mitchell agreements in a separate docket?
It was an agreed upon issue within the operating committee because I felt that way. Wheeling felt that way. I can't make the decision independent in myself, so it was the committee's decision that it would be best to do this.
So I want to be clear what you're saying. The Mitchell Operating Committee determined
Yes.
that the Mitchell agreement should be filed as a separate docket than this case?
No, that would be, for Kentucky Power specific? Is that what you're asking?
Yes.
Yes, that would be me. I
Okay.
made that decision.
And just to make sure that I'm clear, that your reasoning for doing that was thought that the New Mitchell agreement should stand on their own merit.
Stand on its own merit, and also from the permitting perspective of the time-sensitive nature of the requirement of the environmental work to be done.
I'm going to combine a couple issues with what, to follow up on what you just said. In your application for approval of the New Mitchell agreements, and I'm going to, the case number to be clear, 2021-00421, Kentucky Power asked for a decision by February 17th, 2022. The information that's being given for the reason why is not very clear. So can I ask you, to the best that you can, explain why the February 17th date was selected? And also what happens if it's not met?
Well, from my understanding, it's a time-sensitive issue, as I've mentioned a couple of times, because of the environmental compliance nature that has specific deadlines that are required. That's why we put the February 17th, 2021 date out there. And this is strictly from my understanding. If we are not able to do work in a timely fashion, then we would be in jeopardy of not meeting requirements. That could be a serious issue, a violation.
And I can tell you, we will explore this further in the Mitchell agreement case. But you mentioned you understand their specific deadlines. Do you know what those deadlines are?
I do not off the top of mind.
And I'm also looking at the 10-day updates that have been filed in the past, in both this case in 2021-0004. On October 25th, 2021, I'm going to read from the update. Wheeling Power Company is moving forward with CCR/ELG work at the Mitchell Generating Station, given the recent action by the West Virginia Commission on the petition. Kentucky Power will work to bring the Commission a recommendation on how to handle the Mitchell operating agreement, either in case number 2021-00370 or in a separate docket. The company expects to make an operating agreement filing in fourth quarter 2021, and further plans to address through that filing that Kentucky Power will pay only for CCR-related costs associated with the CCR/ELG projects. So my question goes back to, if Wheeling Power was able to move forward with CCR and ELG work, what, other than permits, as you said, was there any other reason for the February 17th deadline?
Well, from my understanding, it's what I've said recently. It is to ensure that from a timing perspective that we can meet those requirements that are environmental requirements so that we're not exceeding deadlines.
Okay, so I think what you're saying is you understand there are deadlines that have to be met, but you don't know what they are.
I don't know those dates specific.
Okay.
I apologize. I don't have those with me or memorized.
Well, one of the hearing topics that was provided by the commission had to do with all of the regulatory approvals to be provided. In the response filed yesterday, whoever else worked on it, referenced certain filings more in generalized, and also referred to your testimony that was filed in 2021-00421, pages 5 to 9. In order to move this along, I will just simply note that in that testimony, there's not a great deal of specific information about permits. So I want to go back and check about something else filed in that application. Again, this is 2021-00421. You mentioned that, or the company is requesting an order on or before February 17, 2022, to ensure the timely transfer of permits was one of the criteria. So could you tell me what permits need to be transferred? Because I did not see that in the response.
Go ahead.
Sorry. I'm finished, I'm sorry, go ahead.
Okay, I apologize. Well, I'm not 100% sure what those permits are.
So you're not able to answer with any great detail about the federal, state, or local regulatory approvals that have to be obtained?
Specifically, those permits, what they entail, no, I'm not.
Can you tell me who might know?
I'm sure, Gary Spitznagel will know what those are.
So if we were to ask in a post-hearing data request, that could be answered?
Yes, it would be.
In the response filed yesterday in regard to the federal, state, and local regulatory approvals that had to be obtained regarding Liberty, Kentucky Power, and Kentucky Transco, I did not see any discussion in depth regarding the transmission agreements, and particularly the AEP's transmission agreement that's on file with FERC. Would you agree that there's going to have to be some sort of regulatory approval for change in that? Or, to the best of your knowledge, does AEP intend to move forward with the agreement as it is, knowing that Kentucky Power will be operated by a different entity?
Are you talking in reference to transmission or Liberty purchase? I guess I'm confused.
I'm talking about the AEP East Transmission Agreement that's on file with FERC, and whether or not there will need to be any regulatory changes to that is one piece. So I'll start with that.
I'm not exactly sure if there would need to be, but I'm sure we've got individuals who can answer that. But for me, I'm not 100% sure of what that would be.
And while I expect that this will be explored in other cases, I just want to make sure that we're out there. It's not clear that any decision's been made about how the pending acquisition would impact the AEP East Transmission Agreement.
I can't speak to that today. I have no knowledge of how that would work.
I think I'm going to save most of my regulatory approval questions for a post-hearing data request because it's sounding like I won't be able to get the information that I needed. Let me just ask about two other things for the Hart-Scott-Rodino, the federal pre-merger notification. Has that notification been made yet?
I'm not sure. I have no idea.
And what about the Committee on Foreign Investment?
Same answer. I have no idea.
And will that probably be filed by Liberty and Kentucky and AEP? You don't know?
I mean, I'd love to be able to answer your question, but I'm not sure legally how that actually works and who makes those filings. Although I've been through a numerous number of transactions before, I'm not sure who would do that.
So in your response, when you noted that appropriate notice will be provided under the Hart-Scott-Rodino Antitrust Improvement Acts and the Committee on Foreign Investment, was that more generalized knowledge than specific knowledge?
Yes, it's generalized knowledge, just knowing that that has to be done, but who specifically is going to do that, I'm not sure.
In regards to customer response, In your response, you indicated that, sounds like you haven't had any complaints that need to be elevated, they've been addressed. All right,
That's correct.
has Kentucky Power received any concerns regarding a potential rate increase arising from the acquisition?
No concerns.
And you had mentioned the employee response to the pending acquisition, if improved. Although I'm reading through the stock purchase agreement, to the best of your knowledge, is there any agreement between Liberty and AEP regarding employee retention?
I have no idea about that. I just know, like I testified earlier, that when the Liberty individuals went around and met with employees, they told them that they would have a job, but I'm not aware of any of such agreements.
I just have a very few more questions, and again, I don't want to replow ground that's already been plowed, but I want to make sure I understand a rough timeline. You mentioned that Liberty had received a courtesy copy of the revised Mitchell operating agreements. Did Liberty receive a courtesy copy after they had been finalized, or was it during any negotiation process?
I'm not sure if they had been given copies along the way. I know that when it was done, and that's my terminology, courtesy copy. Use the word friendly, whatever we need to use there, because they're not a party to the negotiations of the new Mitchell operating agreement. And then there were no objections from them on the final copy.
So it sounds like you don't have any information about any information Liberty might have received, any copies of anything Liberty might have received during the negotiations?
Not to my knowledge. I know they received a copy of what's put before this commission today.
One moment. Staff has no further questions.
Thank you. Commissioner Butler, do you have any questions?
Not at this time, thank you.
Thanks. It looks like Chairman has not been able to log back in, so I have a very few questions. I don't know if you're going to have redirect.
I have like a minimal number of redirect.
And then I know we wanted to discuss timing. We've been going about an hour. Do we want to take a very short break and then I can ask my questions, you can do your redirect and we can talk timing, or would you prefer to?
If we could wrap up Mr. Madison before lunch, that might make a cleaner
I'm trying to get it
transition.
all done before lunch, if everybody could.
Yeah, I don't eat lunch, so it doesn't.
Why don't we take a 5-minute break, then we'll finish up Mr. Madison and then have the discussion we were going to have regarding what we can figure out about timing in the 421 case.
And that
And the post-hearing data requests in this one.
and that sounds great. Well, we can go off the record now.
Okay. And we'll go off the record for about a 5-minute recess.
Well, before would it be okay
Everybody get seated and then we'll, no, you're fine. You're fine. Chris? Or anyone? There we go, okay. And we're back on the record. I think it's my turn to go, Mr. Madison. If you can get your camera back. I'm not sure if that's a camera issue or if it's turned off. I think it may be a camera issue. Because it doesn't show the screen like it normally does. There's the camera on. There we go.
Does it, okay, does it show me?
Yes.
Okay, good.
I just have a few follow-up questions. I think everything that I was going to ask has been covered ably by council. But I do have, I know we've discussed the February 17th date quite a bit, and I understand the rationale. Has there been any discussion at Kentucky Power or among the operating committee about what's going to happen if Kentucky and West Virginia again come to inconsistent decisions about the agreements that have been submitted?
To my knowledge, I've not been privy to those conversations. Are you talking about on the Mitchell agreement, if Kentucky rules one way and West Virginia rules a different way on points that are maybe opposite of each other? We've, to my knowledge, not had those discussions.
Okay. Even with what that would do to your timing of commencing environmental work?
Not to my knowledge. Quite honestly, I think that what we're trying to do in the Mitchell agreement is not change necessarily the entirety of the agreement, just a few items, who the operator is, if there's a sale, and those type things. So I don't believe we were anticipating a differential of opinions.
Okay. Do you know who is which entity is planning on filing for permit changes for environmental permits related to CCR and ELG? Is that going to be Wheeling or Kentucky Power?
To the best of my knowledge that I understand it, until such time that the operating agreement, the new one, is accepted and adopted, those permits right now are in Kentucky Power's name. So I'm assuming with the February date, we're hopeful that those would move to Wheeling.
And this is a question just at a very high level. I don't want to get down in the weeds on this, but has Kentucky Power internally started to explore its status in PJM post-transaction?
Not to my knowledge. We have not done that.
Those were the only questions I had.
I just had two small areas.
Okay, you may proceed with your redirect.
Okay. Mr. Madison, can you hear me okay? Because I'm told I don't speak very loudly, although my children would disagree.
No, I hear you fine. Thank you.
Okay. Were you a part of the negotiations between the owner of Kentucky Power, American Electric Power Company, Inc., and Liberty Utilities in connection with the proposed sale of the Kentucky Power stock held by AEP to Liberty Utilities?
Not at all.
Okay. And during, subsequent to during the most recent break that we had here, did you have the opportunity to discuss with persons inside the parent the nature of Liberty's involvement and understanding and acceptance of the proposed changes to the Mitchell operating agreement and the creation of the ownership agreement and then the operation and maintenance agreement?
Yes, I did.
And could you just briefly relay what your understanding is now?
Yes, the words that I used, repeatedly is they were given a courtesy copy of the final Mitchell operating agreement as we filed it. However, it's come to my attention that they were much more involved in the process with the parent company and involved more so than I realized. So I believe they were able to speak in component parts of the Mitchell operating agreement
And is,
along the way.
I'm sorry, Mr. Madison, I didn't mean to cut you off. Did you complete your answer?
Yes, I'm done.
Okay.
Yeah.
And is it your understanding that the Mitchell operating agreement is a schedule to the stock purchase agreement?
Did it say, I'm not following what you mean there. Mark.
That it's attached to the stock purchase agreement?
I believe it will become part of it, yes.
Yeah, okay. Now, I'd like to change the,
Your Honor, I'm unclear for Mr. Overstreet's question. I just like it clear for the record. Does he mean the current agreement or the one that has been filed with the parties?
No.
He means the Mitchell operating agreement.
thank you, Ms. Grumman, that's an appropriate clarification. What I meant, and I'll restate the question so the record is clear, the proposed ownership agreement and the proposed operation and maintenance agreement, are they appended to the stock purchase agreement?
Yes.
Okay, thank you. If I could change the focus now onto the line of questioning about the timing of the filing of the Mitchell operating agreement with this commission and with the West Virginia Commission and with FERC. Are you familiar with Kentucky Power's motion in this docket for a declaratory order regarding the need for Wheeling to obtain a CPCN?
Yes, I recall that. That was where the commission chair, Mr. Chandler, had asked a question that at the time he didn't even know if Kentucky Public Service Commission would be required to ask for a CPCN from West Virginia before they could begin any work.
And then the commission issued an order on October 8th, in which it essentially denied the requested declaratory order. But it
Yes,
also, I'm sorry?
No, yes, I recall that.
Okay. Do you have that order in front of you?
I do. Could you refer me to the page number?
Sure, it's page 9,
Okay, I'm there.
and and I've got it on a little phone, so I'm not sure where it is. It looks like it's the first full paragraph. It starts, "The commission expects Kentucky Power and Wheeling." Do you see that?
Yes, I could read it for you if need be, but I can see it.
Okay, would you in fact read that into the record?
Sure. The paragraph says, "The commission expects Kentucky Power and Wheeling to promptly seek modifications to the Mitchell operating agreement should Wheeling move forward with the ELG project. In particular, the provisions designating Kentucky Power the operator of Mitchell and assigning it certain responsibilities in that role. The commission further expects Kentucky Power and Wheeling to promptly seek modifications of environmental permits related to ELG currently held in Kentucky Power's name. These modifications will be necessary to ensure Kentucky Power's representations that neither it nor its customers will bear any of the cost of Wheeling's ELG project." That's full paragraph.
Thank you, Mr. Madison. That's all I have.
Does anyone have any recross based on the redirect?
No.
No.
Ms. Grunman, do you have anything further?
Yeah, I do. I just want to flesh out some of the details. Mr. Madison, your counsel asked you if during the break you had the opportunity to speak with folks regarding Liberty Utilities' involvement in the operating agreement. Can you just clarify specifically what it was you learned about their involvement, about Liberty's involvement, and to that point specifically who at Liberty was involved?
Well, first, I don't know specifically who at Liberty was involved, and I don't have specifics, but what I learned was that they were more involved in the process than I originally thought they were. That's what I learned.
How did you learn that they were more involved? In what sense?
I was told that they were.
Oh, so you were just simply told they were more involved?
That's not what I said.
Okay, so what were you told?
I was told that they had the opportunity to speak in modifications and changes or speak to those along the way, and then they accepted and agreed to them. I kept using the term, it was just a courtesy copy, and they had no objection. So I was given a little bit more information than I had prior to the break.
Okay. So it's your understanding that they were part of the negotiation process for the revisions to the Mitchell operating agreements?
It's my understanding they were much more involved than what I had alluded to in previous testimony today.
But you don't know who the individual within Liberty, persons or persons within Liberty Utilities who would have had that involvement?
I do not know their name.
Okay, that's all the questions I have.
Any follow-up? Okay, I believe then that is it for Mr. Madison, is that correct?
Yes, thank you, Your Honor.
Do you have any further witnesses?
No, Mr. Madison's our sole witness, Your Honor.
Okay, and so that apparently concludes our evidence for today. Are there any motions at this time other than the motion for informal conference and the discussion that we're going to have? No motions from anyone? Okay. Well, let's talk about deadlines and I guess just talk generally about how we see things proceeding in the short term.
I wanted to make sure, I do have ideas for deadlines for the post-hearing data request and the responses.
Okay, let's go ahead and deal with that then and get that out of the way.
Before we do that, can Mr. Madison be excused?
Oh, yes, absolutely.
Okay.
Any objection to Mr. Madison being
I'm sorry, I didn't mean to
excused?
interrupt you, I just saw the symbol up there. Mr. Madison, you can be excused.
Thank you. I'll go on mute.
Okay, we were going to discuss post-hearing data requests for this hearing.
Staff would propose that the issuance date be Friday, December 3rd. So we would get our post-hearing data requests out on December 3rd, and that Kentucky Power file a response by Tuesday, December 14th.
Based on what you've heard during the hearing, is going to be the content of the request. Does that sound workable to you, Mr. Overstreet?
I see Mr. Crespo, is Ms. Blend on? That's satisfactory from my schedule, but I would need to consult with Mr. Crespo and Ms. Blend since they're other than, sounds, he said it's okay? He said it's, Mr. Crespo said that's fine. And Kristen.
Okay, then we will put that in a post-hearing order just to memorialize that. So I think our other issue that the motion for an informal conference was on, which I think I've got it in front of me, but in case I don't, was, refresh my memory, that was about the
Yeah, we
Mitchell
did-
order?
Well, we didn't really make a motion for an informal conference. We suggested that if the commission was inclined to cancel this hearing, that alternatively it could be used as an informal conference date, because we thought there were some important issues to discuss, such as the timing in the 421 case, because Kentucky Power has requested that a decision be reached by February 17th. We thought that might be a little tight, given the substantial review that we think is probably necessary in that case. So we just want to talk through that issue.
No, and we can take a few minutes now to do that if all the parties are willing. Ms. Bensel, has staff come up with any preliminary proposals, or is it still under discussion internally? The time we would need, or staff would need?
Staff has come up with a preliminary schedule. We've made it clear that while we would use our best efforts to meet that February deadline, it may not be possible given the need for robust review.
Obviously not committing you, any preliminary indication when your first data request might go out in that one, just so people can start planning?
Yes, let me, got it right here. We're looking at a first data request being issued on December 15th. And because there was an abbreviated time period, we're looking at responses by December 22nd. A second request on January 7th. Responses on January 10th. Intervenor testimony on January 14th. Data request to intervenors on January 28th. Intervenors' responses to those data requests on February 4th, and Kentucky Power rebuttal on February 9th. I would note this schedule does not allow for a hearing at this time, which we're probably going to want to schedule on, so.
Well, the other issue would be that the intervenor testimony would be due 4 days after getting the second set of discovery answers. And so that may not be enough time.
I acknowledge that.
And just to be clear, the first data request being due on the 15th, would that be an opportunity for the AG and KIUC as well as staff?
Oh, yes, yes.
Okay,
This is for all parties.
okay.
And while, we're the ones asking for February 17th, so I recognize that fact. And we will do our best to turn around the responses in the 7 days allotted, depending on the number and the complexity, but we will do our level best.
Well, one thing that comes to mind, I don't know if we're on the record or not, but you've got 2 weeks for intervenor testimony to DRs, to intervenors.
Mm-hmm.
Why don't we just take a week
Okay,
and make the intervenor testimony due the 21st, and that will give the company 7 days to get the questions to us.
let me ask, which date again you were?
Move the intervenor testimony from the January 14 to January 21.
And then we'll have to push back the data request also.
I think we need a reasonable period of time to do the data request. Mike.
Okay, well, then just push everything by a week.
And, the commission is not prepared to discuss our need for a hearing, but it sounds like at least some of the expected interveners would expect to ask for a hearing in this matter. Is that accurate?
Depends. Lawyer answer.
Well, I think that this case with the mutual agreements warrant a hearing, even if it's a one-day hearing, yes.
So it sounds like we're obviously going to need to work in a hearing as well.
Yes.
I think Ms. Vincel's schedule, her providing the tentative schedule is useful. It might be appropriate for, if we could, meaning Ms. Glass and my cohorts in Columbus, if we can discuss this and perhaps come back, and I heard what Mike said, if we could come back and make some suggestions or something like that. It's kind of hard to do. I understand, again, that we're the ones requesting it. It's kind of hard to do this on the fly, particularly when I can't discuss things with them easily.
I don't know how formal we are here.
No,
I
that's
would
fine.
agree. I see no good reason why the parties don't have a discussion and try to come up with a procedural schedule that will work, that includes for a hearing And I can work internally to have discussions about that.
Okay, does that work for everyone?
Yes.
Okay. And we can obviously check the West Virginia docket, but do you know if any procedural schedules have been entered in that West Virginia matter?
I think not, because as of yesterday, I don't think there'd been anything entered in West Virginia since the, well, I'm sorry, that's a different case. I don't know.
Okay.
I double checked and I did not see one, but
Okay. Okay. Once again, I'm overruled. Can we take a recess and perhaps we can come up with something more concrete before we leave here today?
Is that okay with everyone else? I mean, we
Yes.
won't be able to come up with a hearing date
Understood.
today, or in the next hour, so. Oh, sure, we can take, how long do you think you need, 10, 15 minutes, or do you think it'll take a little longer?
Ms. Blinn thinks that we can get it done in 10. I'll be my usual pessimist and say 15.
Okay, well, I'll be close. I will leave, we'll go off the record, and then we can go back on the record, figure all this out, and adjourn this hearing.
Okay, thank you.
We'll be in recess.
Okay. And may we use one of the conference rooms to call Columbus?
Yeah.
What date did you have referred?
Okay, we are back on the record. Mr. Overstreet, did you have anything to?
I have a proposal I would like to, for lack of a better word, propose.
Okay,
And so, the start and end dates would be unchanged, but we would reallocate time within that, looks like about 2-month period. And so the first change we would propose is that instead of, so right now, under the schedule Ms. Wenzel handed out, our responses to the second set of data requests would be due January 10th. And then we would receive those on the 7th, so we would.
That's got to be a typo, I apologize.
Okay, well, that was a little bit of our concern, but I
Yes.
have a suggestion,
Yes, please.
in that our responses would be due on the 14th. That would give us more than just a weekend to get them done. And then we would bump interveners' testimony back to the 20th. And then we would shorten the period for our data request to interveners to the 25th.
DRs to interveners, 125.
Oh,
Okay.
I'm sorry, the request for information to interveners to the 25th.
Right.
I can tell you that will not work for the commission. If we've got 1, 2, 3 business days to draft, let me make sure here. No, I'm good. No, I'm not, I'm sorry, I'm confusing myself. Unfortunately, only having 3 business days to draft, finalize, and issue data requests is not terribly doable for the commission. We'll need additional time. Our processes are such, we need time.
Understood. Do you have a suggestion?
Well, before we do that, the 20th is only 6 days after the supplemental DR answers, and it's a Thursday. We could probably live with one more day, Friday, a week. So in other words, the 21st.
Okay. And I think we just need to see how that plays out further down the line.
Well, yeah, that's still very tight, but.
Right, because right now you have 4 days under the stalking horse.
Right, which was way too short.
Yeah. Okay.
And just to throw something out, I would offer up to move the supplemental request to an earlier date, but I can tell you, we've got about 4 rate cases, major orders that have to get out in late December, so we're going to be, the staff that are going to be working on this, not to make excuses, but we're going to be pushing it as it is. So that January 7th date for the second round of data requests is pretty much a hard date for the
And
commission.
we kept that.
Yes, I just want to make sure in case we started
Oh,
jiggling other dates.
Moving earlier, yeah.
So if the intervener testimony was filed the 21st and request for information to the interveners went the 28th, I'm sure that my coworkers will dislike me greatly, but we can live with that.
So the data request to interveners would be the 28th,
Yes,
and then the responses would be
the February 4th.
February 4th. And then our rebuttal would be on the 9th.
Yes.
It's a weekend, 3 business days. I mean, it is what it is.
That's what it is. Mr. Crespo, Ms. Blend, any thought on that?
Yeah, we're good here. Thank you.
Thank you. I don't know if you heard that.
Okay. No, that's fine.
Okay.
I'm sorry. I was like, yes, it's fine. I think I have to say what is, I can't dance around. It's going to be very hard. I can't speak for the commission by any means, but it's going to be very hard to have a hearing and get an order out by February 17th. So I think you can expect to see in the first data request an understanding of what the hard date is, and why, and what would happen if it's not met.
Understood.
Anybody have anything else they want to bring up today while we're here?
No, thank the AG, and to the extent Mike joined, the motion to handle this today was a good one.
Any other motions that need to be made now? Okay, I think we've already dealt with the post-hearing data requests for this matter. I don't think there's any confidential material, so we don't need to deal with that. So unless I hear otherwise in the next couple of seconds, I think this meeting can be adjourned.
Thank you, Madam.
Thank you.
So we are adjourned. Thanks.
Thank you.